Submission matter.
All fresh will be coming within 2 days. All fresh matters will come within 2 days.
I will be pardoned to mention, my lord.
Petitioner is a senior citizen and is cardiac patient, moving the application against the order of rejection of 205. Case is adjourned to 2nd of April.
You have already filed the case.
Yes.
When have you filed?
And 3rd of March.
All the fresh matter will come with it today, tomorrow and day after. All the fresh matters.
My lord,
Need
I
not
have,
mention.
my lord, I have,
Yes.
I will be pardoned, my lord. I have,
No mentioning. Straight away. Yes.
my lord, last week I have mentioned on CRLMC 1605 of 2023, 2 तारीख अछि. Interim order nahi tada seti debbeni last week. So
Give the
inadvertently,
memo. Huh? Yes.
it may come tomorrow, my lord.
Call the list. Straight away. Item 1.
Oblige me.
Item 1. Item 6 permitted to withdraw with legal. Item 6.
I'll come. I'll reach immediately. 1. Here.
Item 1 on behalf of Mr. Acharya, I pray some other day he has some difficulty, my lord.
It will go to July, I tell you. Because I am listing all the press matters, those who are not heard. Will go to July. On the request of the council for the petitioner, read the matter. Yes, next. I am calling the list because I have a seat. I will not waste time in mentioning. Yes. Item 2. Next. Yes.
Item 2, Miller. Your lordship, kindly see last 2-3 orders, Miller. The last 2-3 occasions, Miller, Lord and Council for the state took time, Miller, to take instruction in the matter, Miller.
Yes.
Matter is relating to Miller.
Yes.
What is this matter is about?
Miller, matter is that, Miller. Your lordship, kindly see Annexure 14, Miller, the order, Miller. While moving an application for discharge, Miller, the relevant portion of the order is at page 67.
67.
Miller. I moved an application for discharge. In the application for discharge, Miller,
Yes.
the matter was posted for 11/7/2022 for final form, Miller. Then, Miller, when the police, Miller, didn't file the final form, the learned magistrate, Miller, the learned court will, Miller, the learned judge direct personal appearance of the IO, Miller, and the Miller several times the matter was adjourned. When, Miller, the order of this honorable court, Miller, the honorable special judge was not complied, Miller, he, Miller, posted the matter for charge. Then, Miller, I filed a petition before the trial court. This is because the final form has not been filed and this matter was dragged on, Miller, from the Miller for filing of the final form. So, Miller, without compliance, Miller, how, Miller, again the matter is posted for charge, Miller. That was rejected.
On hearing the rivals of the
Preliminary CS has been submitted.
That was rejected. Miller, I am coming. That was rejected. That is why, Miller, I challenge, Miller, I filed this LMC, challenge that order. Your lordship has directed my lord and friend, Miller, to take instruction why final form has not been submitted. And, Miller, why the order of the learned magistrate by Annexure 14, it has not been complied with.
Where is that order of magistrate?
My lord,
Which order?
my lord, the Annexure 14, my lord, page 67, my lord, I am saying.
I am reading there. What do you want to say here?
My lord, the last line, page 67, my lord. The story is submission of the learned counsel for the accused has got no merit and stands rejected. Put up on 11/7/2022 for final form, my lord.
Yes.
There, just a minute. Then, my lord, I am showing, Lord, page 15 of my petition, my lord, wherein I have given all the dates.
Yes. Page
Then,
15.
Page 15, my lord, the paragraph 23, my lord.
Yes.
That when the order dated 36/2002 has not been complied with, the Lawrence Special Judge Kendrapada posted the matter to 11/7/2022 for submission of final form. And when it was not received, again the matter was posted to
Page, you are reading where?
page 15, my lord, paragraph 23.
15.
15, my lord.
23. Yes.
Yes.
When the matter was.
Order dated 36/2022, my lord, Annexure 14, my lord, has not been complied with. The Lawrence Special Judge Kendrapada posted the matter to 11/7/2022 for submission of final form. And when it was not received, again the matter was posted to 22/7/2022 for final form. On 22/7/2002, when the IO did not submit the final form, the Lawrence Special Judge posted the matter to 3/8/2022 for personal appearance of the IO to explain why he has kept the investigation open and posted the matter for 3/8/2022. On 3/8/2022, IO appeared through learning PP and submitted explanation as reflected in the order, my lord, dated but the order dated 36/2002 was never complied with. Subsequently, the learned special judge posted the matter for framing of charge on 19/9/2022. My lord, thereafter, my lord, we filed the petition, my lord, by 15 series.
Final
The-
form is filed or not?
No,
No, not final. It is open, my lord.
my lord, I'm submitting, my lord. Well, I have two lines more, my lord. Two lines more, my lord. When this honorable court had the matter, my lord, directed my lord to take instruction, and as well as my lord, on the basis of my prayer, my lord, your lordship had, my lord, given an opportunity, my lord, to file a petition for adjournment, my lord.
Yes.
Time and again, my lord, 3 times the state council, my lord, took.
Last time you also did appear.
Yes, my lord.
Two times.
My lord, what happened here? Your lordship has directed that your lordship can see your lordship's last order.
Now let us see the instruction now.
Now, what happened in the meantime, my lord? What happened in the meantime, my lord? Well, instruction that no final form has been filed.
Yes.
What happened in the meantime, my lord? Your lordship has directed that matter be listed on.
Take it after 2 weeks, so that I will bring the latest status with regard to the investigation.
That is a, my lord,
But where is the legal bar? They can proceed. 173(8) is open.
open. My lord.
Doesn't mean that the entire
No, my lord, I am not on that, my lord.
entire charge sheet which has already been filed will be ignored and wait till the police files, then only the.
My lord, that was the order of the learning special judge, my lord. That is why I am saying, my lord. The
They can
learning
just say that final form.
file and form.
If they
That
don't
is what
file
the-
it,
Yes.
awaiting the final form, which is the 173(8), why should the court will wait?
My lord, because if your lordship will come to the merit, my lord, I will
And
say, my
can
lord.
that be a ground that the final form is not being filed, so therefore whatever has been filed, you
My
ignore
lord,
that and discharge?
my lord, when the order of this honorable court, my lord, suppose, my lord, this honorable court has passed an order, and this, my lord, the order of this honorable court has not been complied with by the state, my lord. Time and again, when your lordship is saying that
I
you
thought I only asked them to get the status.
no, my lord, that is, I am saying about the special judge, my lord. He is, my lord, time and again, my lord, the matter, my lord, posted to 6-7 times, my lord. And personal appearance of the IO has already been done, my lord.
Now, what is the state according to
Stays
you?
in, my lord, my
1
lord.
minute, what is?
They ignored the prayer, my
Wait,
lord.
wait, they are not ignored.
The
They are
preliminary charge sheet has been submitted.
Hmm.
I will bring the latest.
final form has been filed.
Final form is not. Immediately is open.
Let us for the state. I think we need to get the instruction whether final form in the present case has already been filed pursuant to the order dated. What is that order? You have shown me which order?
My lord, order of the learned,
60.
order of the learned trial court, my lord. 67, my lord.
Order dated 16/7/2022 passed by England Special Judge Chandrapura. Please the matter.
36/2022.
30?
30th June 2022.
30th June 2022. Yes. Yes. Right.
But the interim arrangement may continue.
Interim order, interim arrangement to correct.
Interim arrangement.
Pass out, yes. On the request, again, June, everything will do. Yes.
Item 5. This application is arising after disproportionate file.
Sorry?
TA case.
Hmm.
Arising from a TA case.
Hmm.
The PW7 who was the assistant director of statistics during the examination stated that the vigilance IO has submitted a request to him including 5 members of his family for calculation of the expenditure and income for household article.
No, you are agreed by what?
Pardon, my lord.
Agreed by what? Recalling.
No, my lord. Actually, the daughters are reading and Bhubaneswar, they are not included in the family. But the request is sent by IO that including the family member, the 2 daughters. So the petitioners have filed an application to recall the request, madam. That was rejected by the court.
Recall what?
Request.
Requisition.
Fine.
Okay. Show me the order.
Page 7, madam.
Yes. Operating part.
Operating page 8. Last one.
What are the documents you are seeking?
That is the request, sir. Request, sir. It was sent by the IO for its calculation of the. Consumer expenses.
Yes. What is? He has a right. Petitioner has petitioner. Huh? What is the stage now? No, examination of how many witnesses have already been. What is five witnesses out of
35 exams are here.
Out of 53.
out of 53, 35 examined.
35 people.
I issue notice you are not sure about it. It ploy for delaying.
Secret proceed
Then why have you opposed there in the trial court? You should have allowed. Here, right, petition rejected by the order dated 18/1/2024, passed by Learned Special Judge Tenkana in PR case number 77 of 2017, whereby the application of the petitioner seeking requisition of the original document. Original document from requisition letter, na?
So number 3539.
They sent for a requisition to Assistant Director Statistics regarding the number of the family members, place of posting, and income of the accused for calculating the consumer expenditure on the basis on that basis, and what on the basis of which the DA has been calculated during the check period has been turned down. The trial court in the impugn order has observed as under while rejecting the application. Page 8, perusal of the prayer made by the petitioner seems to be innocent, as no prejudice is going to cause to the prosecution. Hence, the application moved by the petitioner deserves merit. Accordingly, the trial court ought to have allowed the stay. Where is that application? Copy of application. Where is that application? 60. Regard being head
Page 17, my lord.
17. Regard being head to the which 17 objection, that is your objection. Regard being head to the submission made by the parties to the bar, the petition is allowed, and the application moved by the petitioner on 26/9/2022 or 23, 22, praying for application also. What kind of application? Very difficult to make out. Praying for calling the requisition sent by the IO to the Assistant Director Statistics allowed, huh? We allowed. Accordingly, the petition is allowed. Yes. Yes, next.
Item 6.
Withdraw. Yeah.
Item 7.
6, I may be permitted to withdraw with liberty to file with the fresh cause of action, my lord. We had filed for discharge.
No, with the liberty to file fresh petition if cause action success.
Gratefully lodged.
Item 7.
7, refer one week after. Refer 1 week after.
Done.
Item 8.
May I please, my lords? My lords, in item 8, there are two cases, my lords. One is 4896 and the other is 2642, my lords. Both the matters have been settled, my lords, in the meantime. Lords, both the parties are present before Lordship.
What are the offences?
Lords, in the second connecting matter, Lords, that is 2642. Offences are under section 341, 294, 323, 506, and 34 of the Indian Penal Code, Lords. And in the first case, Lords, similar offence, only additional offence 353 is there. Inter-office dispute, Lords, the accused in the first case was a junior engineer, and the
What are the allegations?
Lords, it is alleged that the first initially the FIR in the first case, that is 4896, was lodged, Lords, by the petitioner in the second case, Lords. Therein alleging that the the other person had entered the office premises and abused and in filthy language and threatened with dire consequences, Lords, to his office superior. And as a counterblast to that, the second case was lodged by the both are engineers.
Yes.
Yes. Who is Lakshmikant Pohan and Arthatrana
Sahu.
Sahu. And what about the other case? Who all are they? Same party.
Lords, same.
Arthatrana has filed his first case. The instance of opposite party to the FIR number some the petitions. Charge sheet filed?
My lords.
Where is the first case? Where is the charge sheet? Where is the charge sheet? Give me the dates. Problem is you people don't file anything. That's the problem.
Lords, in the second case, I filed, my lord.
The first case I am talking about. What is the stage now?
My lords, cognizance has been taken, my lords.
Date of cognizance?
My lords, date of cognizance 19/8/2021.
Why have you not filed all these things? Why for your keeping secret?
Lords, I beg lordship pardon.
It is
I
there
am
on
in the
record, Your Lordship. Unfortunately, I'm held up in another.
Where is
It
that?
there.
There is
Your Lordship,
nothing.
in the date chart,
First
I
case I
have
am talking about. The first case.
Lordships,
Where is
Lordships, the
it?
date chart,
Where is the
in
charge
the
sheet?
date chart. Your Lordships, I have filed the charge sheet. It is there on record, Your Lordships. I'll give,
Where is
I'll
that?
Lordship, kindly pass it over. I'll come.
No,
Your
no,
Lordship.
pass
I'll
over.
just-
Okay.
Charge sheet, my lords.
31/7/2021.
Charge sheet dated
31/7/2021.
448, 332 added. On 31/7/2021, the charge sheet in the present case has been filed for alleged commission of offence under section 341, 323, 294, 353, 506, 448, and 332 of IPC. And the court learned which court has taken cognizance. The learned ATJ Bhadrak by order dated 19/8/2021 has taken cognizance of the offences mentioned above. Before the charge is framed and the trial is commenced, the parties have entered into a settlement. According on the basis of the settlement term, the petition has been filed. The petitioner and opposite parties are present with the court today. They are being represented by their respective counsel and identified by them. They have also filed self-attested copies of their Aadhaar card to submit their ID. They are taken into court. Aadhaar card you have filed?
My lords.
Taken into court. The petitioner and the opposite party number 2 have filed a joint affidavit dated Ajit Tarik Video. They shown to inter alia setting it under 1 to 5. 1 to 5. The opposite party number 2 is present in the court on the query from the court submits that he has settled the issue to the petitioner, and both the petitioners are government employees.
My lords.
Both he and the petitioner are government employees. There is also a cross case registered against him by the advances of the petitioner, which is also sought to be quashed in the connected matter. In sought to be quashed by filing CRLMC number 24642 of 2024. State council submit that the dispute is PTC party. The petitioner and opposite party are government employees. Since they have settled the dispute and filed a joint affidavit in the court, there is no legal impediment to requesting the FIR according to the FIR part.
Macho.
Item 9.
Yes, sir.
In this case, before submitting my lord, let me make it very clear. I have challenged no order under the Special Act under section 15 or 17. So if it could have been order under 15 or 17, I could have challenged, then this court has got no jurisdiction. Now coming to the peculiarity of this case is, this matter is pending before special court since 2019. And after 2021, till today, no special judge is available there. So this case, confiscation proceeding is still pending. And second part is, here petitioners, they are not accused persons. They are not delinquent. Delinquent in this case is opposite party number.
Let us see, I will issue notice to ascertain.
Question of maintainability. You also can have a glance to the prayer. Page 8.
Yes.
Quashing of the proceeding of CC case number, that of proceeding before the authorized judge. So any order, the order has been passed by the authorized judge. So under section 17, any order passed by the authorized judge.
My lord,
So 482.
But what he says that there is
no order is being passed, either under 15 or 17.
Sir, issuance of notice.
he says that there is
Only my lord, under section 13,
there is no appellate authority at present. There is no appellate authority working. There is that post is lying vacant.
Appellate authority. High Court of appeal file.
High
He
Court
says that see, pending before appellate special court and release the property. Special court is not
special court authorized officer applying.
Court is functioning or not?
My lord,
You made a statement that court is not functioning.
court is not functioning.
Which special,
Authorized officer court is not functioning.
that's what he says.
Since
There is no order
2021,
passed.
nobody is appointed.
Special court of protocol lectuchandi function koruchi na koruchi boli kon 482 hobo. It's a statutory forum is there. Yeah, you could have raised that point in the appeal also.
No, appeal is not.
Writ is maintainable.
Read is also maintainable. Read is also maintainable. Let him file.
Let us go see whether 482 is maintainable, writ is maintainable, there is no officer. Why to go into, you tell me whether officer is working or not. But then we will examine. I'll simply issue notice. Let us see. I'll issue notice. If the officer is not working, he can't be rendered, remediless. Some forum has to take care of that. Maybe 482 court.
Yeah, I have annexed the order sheet, even if entire order sheet I have filed.
But again, it will have to. He has to come to this court only in the form of a writ petition or in the form of a 482 petition. Let us examine whether the officer is there or not.
Issue notice, point of maintainability also.
I will not say, simply I will issue notice. Let us see that everything is open. We'll see that. Okay. I am simply issuing notice, and you notice will go and accept. Yes.
And then
Let us sort it out whether the officer is, why the officer is not working. Let us understand.
If officer would have been there, I would go.
I know, I understand.
I will withdraw this and I will.
You would have gone.
May I please, Lordship? In this case, challenging the order passed by the learned JMFC Dhamnagar in GR case number 23/2023, order dated 4/1/2025, will also kindly have a glance on annexure 6, running page 51, my lord. Running page 51. The petitioner filed a petition under section 323 CRPC for commitment of the GR case number 23/2023 to the learned additional session judge Bhadrak for a joint trial with ST case number 58/20. My lordship, kindly, the prayer of the petitioner was rejected. Your Lordship kindly have a glance on the running page 52. There are two ground was taken. Your Lordship kindly have a glance. Line 6, Your Lordship.
Yes.
The claim that Dhamnagar PS case number 12 by 2023 is a counter case to the Dhamnagar PS case number 101 by 2020 is not substantiated. The alleged time gap, my lord. Your Lordship kindly have a glance.
Can you further? The alleged time gap.
Time gap, my
Between the
lord.
two incidents, there is a serious doubt. About the
Reasonable period.
A counter case is.
Another ground was the rejection of the protest petition by this court is under challenge before this Honorable High Court in CRLMC number 3971 by 2023 until the Honorable High Court decide the matter. Any decision regarding the commitment of the case would be premature, my lord. Your Lordship kindly have a glance on the Annex 7, Your Lordship. Your Lordship's order. The 3971 CRLMC by 2023 was dismissed as infructuous, my lord, on 12/11/2024. My lord.
Yes.
And the first part is the time gap. Your Lordship kindly.
You have to get over the first part.
First part is your Lordship kindly have a glance on running page 42, my lord.
42.
My FAR, my lord.
42.
42.
Yes.
The second para, my lord. 19/4/2020, my lord, on the same date, the another case was registered, Dhamnagar PS case number 101 by 2020, my lord. On the same date, the occurrence start, my lord. The FAR was lost by the petitioner on 14/10/2021 because the occurrence took place from the 19/4/2020. Due to that,
where is it? Let us see the affair.
40,
both the affairs.
Both the affair, my lord. First affair is, my lord, 101 by 2020.
Page 10.
Page 10, my lord.
Page 10. The occurrence is 19/4/2020. 19/4/2020.
Another affair, your lordship, is running page 32, Annex 4. The affair was registered after the direction of the
17/1/20.
Yes, my lord. Registered on 11/1/2023.
No, occurrence.
Occurrence, my lord, on
17/1/2020.
The first
2 days after.
Yes, my lord.
Then you will get over the first.
2 days, my lord. This is the for which we are filed.
How are you connecting these two cases?
Yes,
These completely distinct cases.
My lord, these are different cases, not different cases, your lordship. Your lordship kindly come to running.
2 days after something has happened.
Not on the same date, my lord. Or your lordship kindly have a glance running page. Your lordship kindly come to running page 43, my lord.
43, eh?
43, my lord.
Yes, again.
This on the second para, my lord. 19/4/2020 दिन रविवार भद्रक जिला सरकारी डॉक्टर.
That is 161 statement.
That is the affair, my lord. That is the affair. The police did not register my affair, for which I came to this Honorable High Court by filing one CRLMP number 2598 of 2022. After that, the affair was registered, my lord. This is the problem, that the affair was not registered by the police.
So the first paragraph you read, page 40. First paragraph.
First for विनम्रता सहकारी जनाऊँछि कि निम्न सरकार आवेदनकारी सुरेंद्र कुमार पंडा 58 जिला भद्रक जने स्थायी अधिवासी अटे 17/20 मोर एकमात्र पुत्र देवदीप पंडा 30 श्रीमती सोनलता षडंगी आवेदन आनंद बजार भाइया अन्नपाड़ा थाना भद्रक जिला भद्रक ज्येष्ठ कन्या प्रतिज्ञा 27 बिना यौतुक श्रीजुक्त गणेश मुदुली बरुआ जहांगीर भाइया थाना धामनगर.
So it is pertaining to 17/1/2020.
That is the
that is what the trial court says.
That was the marriage, my lord.
That is the trial court. The offense takes place from there.
The first affair was lost on 19/4/2020, your lordship. And the another, my affair was the date of occurrence is same date, my lord.
What are the offenses? What are the offenses?
Offenses, my lord. 341.
Have you implemented the informant?
Yes.
Where is that? 498 case, you will not implement the informant also. Not at the outset, land counsel for the petitioner seek leave of this court to implead the informant in the present case. Let him do so within a week. If issue notice to the newly implemented opposite party will By opposite party number 2, at least after 2 weeks. Yes. Next.
I have filed an IM.
No, incomplete petition. You don't implead people and you need. Why have you not done it? This is minimum thing. Yes. I should have dismissed it. There is nothing in the matter because I saw 498A, therefore I am thinking to issue notice. Informant is not made party. In a matrimonial dispute, if you don't make informant the party, the wife is a party, how will I proceed? Yes.
Obliged to.
11.
Offense alleged against the petitioner is a 42294. In fact, what happened, the charge was framed, but the party they settled their disputes. Opposite party number 2 is the informant my lord. That's why, because their 294 is there, that is not compoundable. 420 is compoundable to permission of the court. So I filed the petition. Let your lordship issue notice to the opposite party number 2.
They have settled the issue notice to opposite party number 2.
So for further proceeding.
In the meantime, petitioner is at liberty to move application before the trial court, seeking adjournment in view of the fact that the petitioner and the opposite party number 2 have already settled the dispute. If such application is moved, same shall be fetched. Yes.
Item 12.
May I please your lordship? My lord, on behalf of Mr. A.R. Panda, matter may be listed on Monday, your lordship.
No, don't decide the date. It will go to some Monday only, but in July.
My lord, yearly days, my lord.
Partly I allow your prayer that Monday it will be listed, but somewhere in June or July. Okay.
I beg to pardon your lordship, my lord, due to illness, he is unable to appear before
All
lord.
right. Illness then short date do. After 2 weeks. Okay.
Oblige your lordship.
And let counsel for the petitioner on behalf of Mr. Amulya Ratan Panda. Prayer is made for adjournment on the ground that it is indisposed. Please the matter. Yes.
Oblige your lordship.
May I please, your lordship? Well, here in view of amicable settlement and compromise, the petitioner has filed this application for quashing of the affair, my lord. In fact, my learned friend is appearing on behalf of the OP number 2, and to that effect,
What are the allegations?
69 of BNS, my lord. And to that effect, the OP number 2 has already filed an sworn an affidavit before the executive magistrate, which I have annexed at annexure 2, my lord.
What's that? Promise of marriage and all.
My lord. And to that effect,
Okay, it's notice and so and so accept notice on entered appearance on behalf of opposite party on advance notice for opposite party number 2. Then the counsel, both the counsel for the petitioner and the opposite party number 2 conjointly submits that the parties have entered into a settlement. Leave the matter for the installments.
the short date may be fixed so that both the parties can.
Do it. Bring them.
Right.
Yes.
Item 14.
My lord, on behalf of Mr. Jyotirmay Sahu, my lord, kindly take up the matter after 1 week, your lordship.
On the request of land counsel for the petitioner, adjourned. Yes.
15.
15 my lord, kindly taken up after lunch. After lunch.
Pass over.
16.
May I please, your lordship? My lord, in this case, I have challenging the order dated 30th January 2025, my lord.
30th?
January 2025, that is annexed 2, your lordship.
Yes.
My lord, where the petitioner filed an application under section 311 CRPC to recall the victim as well as PW12 minor 13 and 14, who is the parents of the victim. But the learned court below rejected the prayer of the petitioner, my lord. And my humble submission is that, my lord, I have taken averment.
Who are they?
13, 14. Victim and parents, your lordship.
From victim.
PW12 is the victim, PW13 and 14 are the parents of the victim, man. And in between, my lord, my humble submission is that
Offenses?
offenses are 376 and POCSO, your lordship. 363.
Where are their evidences? You filed their evidences.
My lord, evidence is available, man.
You have not filed, you will keep it with yourself, what to do.
At present, I have taken averment in para 4, Your Lordship. That now the victim is residing at the house of the present petitioner, my lord, as a wife, my lord. And she does not want to proceed the case against the
Show me their evidences.
my lord, evidence recall करे.
You don't want to file, that is the reason. I want to see their evidence. If they have already spoken against you.
Yes, my lord.
So then, what are the grounds then? They see your application. Only one paragraph application. There should be sufficient reason to call them.
My lord, as because, Your Lordship, the case is posted for evidence of the IO, my lord. For the examination of the IO, my lord. In between, if the victim will not recall, then he will be convicted, my lord. And now the victim is residing at the house of the present petitioner, my lord. And both the parents of the victim and
I have then, have you implemented them? You have not implemented them.
But my lord, I'm taking averment in para 4.
No. Your averment is neither here nor there. See these. You are saying that the victim girl has started staying with you.
My lord.
Where from I will get unless I will ask verify from them.
Yes, my lord.
The same girl which you claim that she is staying with you, she has gone to the court and deposed against you.
Yeah. Already she deposed, my lord.
Already she has deposed. So now you one line application, one line averment that she started staying with me. So therefore recall her for examination.
No, my lord.
I have seen it, sir. You have not said anything except one line. Para 4.
Para 4, but
unless the victim PW2 and her parents so are allowed to further examination in this case, by the defense, the accused
in page number 13, my lord, I have typed all the questions, my lord.
These are questions.
My lord.
Therefore, you file, implead them and file.
My humble submission is similar putting a lordship at granted.
You have to, I have to write something, or simply you are saying so, therefore I'll pass the order.
Okay.
For writing, I need something on the record. You have not filed anything. You have not implemented them.
My lord, in the court today, I will say.
Not like this.
My lord.
Next day, the petitioner seeks to implead the informant and victim as opposite party to this petition. Let him do so within a week. And in the meantime, the liberty is granted to the petitioner to file additional document to substantiate issue notice to the newly implemented opposite party. Bring them. Then I'll find out the way to help you out.
Yes, Your Lord. My lord, sorted my fix, Your Lord.
Next. 17. First of all, you people don't file a complete petition. Don't file document. Don't implement necessary party.
Sorry, Your Lord.
Don't make any averment.
In this case, I have taken averment, my lord. Sorry, Your Lord.
Say everything orally. On that basis, I have to pass the order. How can it be possible? And POCSO case 376 and all. Yes.
17.
My lords, item 17, my lords. My lords, here the fact is that if your lordship will give me a minute, my lords. In 2020, my lords, while the petitioner was working as IIC Jaleshwar, a audio clip was made viral that he demanded rupees 3 lakhs to release a car involved in a NDPS case, my lords. My lords, pursuant to which immediately there was a raid at my house and 7 places related to me. On 1/9/2020, my lords. Raid was conducted in 7 places related to me. Thereafter, my lords, they did not found anything from any of the places and the DA case was dropped. I was informed the DA case was dropped. Subsequently, my lords, they entangled me in that Jaleshwar PS case under the offences of the NDPS Act for abetting the offence under the NDPS Act. They entangled me in that case. My lords, I challenged that in a 482, my lords, and it came to be stayed by your lordships on 13/12/2024. My lords, the order is at page 30, my lords.
30.
My lord.
Yes. Release the issue notice, release
the next page,
along with 4308 of 2024. Yes.
Now, my lords, what has happened, my lords? After your lordship passed this order, my lords, they have reopened the DA case on 27/12/24.
Therefore, I am issuing notice. Let us see and tag with that.
Copy टे दियंतु ये
Copy-
case drop ହେଇଛି ବୋଲି କୋଉ document
You give a copy, simply issue notice, file process, let it go in the due course.
Well, I'll serve him copy.
Yes.
Great.
Yes.
18.
I may please, my lord. Here, I have challenged the order of cognizance, also the order directing issuance of process, my lord. My lord, may kindly see the page 16, my lord.
16, huh?
The 16.
138.
My lord. 138.
Yes.
As the offense on section 138 of NI Act is based upon documents, inquiry on section 202 of CSP was conducted in this case to verification of.
Yes, I got it. Next.
My lord, did.
Why should it be?
That was when it is the decided ticket again. Your lordship has also decided in 2 other cases of my case, my lord. That where the complainant and his accused person, they are staying outside the jurisdiction of the complainant's court, then 202 inquiry on section 202 or to have been taken, my lord. That is the only one. So here, only on the basis of, it's true, in
212 inquiry is not done.
No, no, not done.
Petitioner is detailing the order dated 10/7/2. Where have you said that 202 inquiry is not done?
I've stated.
Does the impugn order say that?
My lord, I've stated it. My lord, may kindly see paragraph 3 and 4. 3. Paragraph 2 and 3, my lord. Grounds.
But see, you are relying upon this court, this matter. There, the court said that 202 is not required. So therefore, I am proceeding. But in your impugn order, where does the court say that?
My lord, sir, in that case, I've cited on decision of 2016. My lord, I have also taken.
No, the order which you are citing,
Yes.
I have given the
Exactly this point.
indulgence because in the cognizance order, the trial court says that 202 is not required on the basis of available material. I am taking cognizance.
Here,
so therefore, I said that no, 202 is required.
Yes, it is also
but in
the
your
case.
case, where is that?
It is also the case here.
Where is that?
That's
The impugn order, it doesn't say anything.
yes, my lord. That is there. That page.
Yes.
Page 16.
I have read that full.
As the I am reading it again.
As the offence of 138 in so and so, inquiry under 202 was conducted
In this case through verification
of
documents
only. Okay.
Only.
Connotation of notice agreed by the petition, agreed by the order dated 10/7/2023, whereby the cognizance of offence under section 138 has been taken against the petitioner. The trial court, while taking cognizance, has inter recorded as under page 16 last paragraph as the offence under 138. When counsel for the petitioner, relying upon the judgment of this court dated 23/12/2024, passed in criminal MC number 2138 of 2024, submits that if the parties are stationed beyond the jurisdiction of the court taking cognizance, the inquiry under section 202 CRPC is mandatory when taking before taking cognizance of the offences. However, in the present case, admittedly, no inquiry under section 202 CRPC was taken. Issue notice to opposite party. Petitioner may move application before the trial court seeking adjournment in view owing to the trial that the petition is submitted before the spot. Yes, next.
Have filed an IA.
I passed the order. Yes.
My lord.
Yes.
Challenge the order dated 27/12. Here I have challenged the order dated 27/12/2024 at Annexure 1, running page 12, my lord.
Yes.
Here, the offence is under section 138 of the NI Act, my lord. The petitioner with the accused before the trial court filed a petition under section 311 CRPC with regard to recall of the witness, that is the complainant, my lord.
Which witness?
The
Period one.
complainant, my lord. Period one, the complainant, my lord.
Where is his statement? Where is his evidence?
My lord, the petition is at Annex 2, my lord. The leading question that with regard to debt and liability and the transaction of check, whether to disclose the legal liability or not. And the third question is a question relating to Exhibit 7, reply against the demand notice, my lord.
So is evidence whether these three questions you have already asked or not. Let me see. You have already asked, why should you call him? Show me his evidence.
Certified copy will not.
I don't need certified copy. Just give that. Three questions you are
Yes, my lord.
written in the application. You want to put it to the witness whether you have asked these questions or not.
The line and trial court only rejected ground the delay. Delay ground.
Obviously delay because the complaint is filed in 2014. And when the witness was examined?
Well, it examined in 2015.
15 to 2025 you move an application on 311.
24.
24 anyway, 24. It is a 138 NI. 6 months is the time frame to dispose of. How will you explain the delay? Why have you slept over over 9 years? 9 years.
On transfer of advocate brief.
9 years, how can you explain 9 years? Right off. Petition is agreed by the order dated 12 I think 12 yes. 27/12/2024, whereby his application under section 311 CRPC for recalling the PW1 moved by has been rejected. The trial court primarily rejected the application of the petitioner on the ground that the PW1 was examined on 2/5/2015 and after lapse of subjected to extensive cross examination on two different documents. That is on 6/9/2015 and 14/9/2015. After lapse of about 3 occasions, 6/9/2015, 14/9/2015, and 21/9/2015. After lapse of about 9 years, 9 years on whenever we move on whenever we move that application
13/10/2024.
The petitioner moved the application seeking recall of the said witness to pose three questions which is given in the schedule to the application. The trial court has taken into consideration the entire facts scenario of the case and rejected the application. The present case is arising out of the complaint under section 130 NI Act initiated by opposite party against the petitioner, which is pending since 14/11/2024. The under section 143 of NI Act, statutory period of 6 months is provided for conclusion of this trial. But perusal of the proceedings reveals that the trial of the present case is prolonging since last about decade. In that view of the matter, in the reasoning given by the trial court while rejecting the application of the petitioner under section 311 CRPC is just proper and the calls for no interference. Yes.
Item 20,
May I speak as petition of first trial before the learned trial court for the offense under section 340, 376, 2N, 417, 341, 323, 294, 506.
What are you asking for?
Challenging the order dated 13/11/2024, where the learned trial court rejected the petition under section 311 to recall the witness.
311.
My lord.
Not
PW3
recall of which witness?
PW3 victim.
PW3 is the victim.
Victim.
Annex 4 is the petition to recall the witness.
What are the offenses? POCSO is there.
470.
POCSO is also there.
Sorry, my lord. No, POSCO was not there. Major girl, while both the petitioner and
Where is her deposition? Where is it?
PW3 running page 27, your lordship.
20?
27.
77. PW3.
PW3.
Okay, let us see. 24 years, huh?
24 years.
2020.
There was love affairs accordingly while they were prosecuting their study in a school. There was a development between them about the relationship. Subsequently, the petitioner denied to marry. And accordingly, the affair was registered.
Are you now married? No.
I am also married, and the victim was also married. In her deposition, he was stated that he was
But
also.
see, you have cross-examined very extensively. Why are you?
But in fact, there was a love relationship, and
No, why are you calling him once again?
In fact, so question
Have you
number.
settled the dispute?
Right.
Have you settled the dispute?
PW3 was examined in 2022, Your Lordship. The application was filed for recall the PW3 that was.
But till this trial has not been.
November.
They were in relationship.
That's right.
both of them.
2.5 years after, Your Lordship, that petition was filed.
What is the reasoning of the court?
In page, Lordship, that is page 43, my learned friend has filed the application.
One opportunity with the cost.
Yes, Your Lordship.
One opportunity with cost. Petitioner is agreed by the order dated 13/1/2024, whereby the application of the petitioner under section 311 CRPC for recalling PW3 has been turned down. The PW3 was examined
6/2/2022.
Examined on 16 February 2024, and she was subjected to cross-examination by
6 years.
the counsel for the by the defense counsel. After lapse of 2 years, the petitioner moved an application under section 311 CRPC for recalling her on 5/11/2024. The trial court has rejected the application solely on the ground that the application has been filed belatedly. But the High Court, the trial court reasonings are correct reasoning.
Last part, your lordship may kindly summoning repeatedly summoning to
extensively.
the victim, that will be provided for him, that running page number 48. But
The reasoning assigned by the trial court to reject the application under section 311 CRPC is undoubtedly correct. But the fact remains that the petitioner is being an accused, is facing serious charges, and he has already enumerated the questions to be put to the witness in his application under section 311. So the application seems to be relevant. And have you said that somewhere you have settled the dispute? Have you said anywhere?
no matter, That was not specific there, but the matter was.
Therefore, by taking into consideration the facts in entirety, I'm of the view that the petitioner is entitled to at least a single opportunity to further cross-examine the witness for examination. Taking into consideration the submission made by the petitioner and the reasons stated in the application, I allow the application under section 311 CRPC moved by the petitioner and direct the trial court to fix a particular date and afford a singular opportunity to the petitioner to cross-examine the victim, cross-examining the witness, namely PW3, subject to the petitioner paying a cost of 10,000 rupees to the victim on the date of her appearance for cross-examination. It is made clear that in no circumstances petitioner shall seek adjournment in the matter before the trial court, causing delay in conclusion of the trial. Pay 10,000 rupees. 10,000 rupees. Huh? I'll increase it to 20. The reasonings are perfectly correct. I'll dismiss it. The reasoning, just see the reason.
Yes, to fill up the latches lacuna.
Why should the court will interfere? Absolutely correct order. Still, I am giving indulgence because you say that you have settled the.
Only one more, your lordship. PW3 has examined on 6/2/2022, your lordship. 16, your lordship might have 6/2. So, these are vice examined.
Okay. Asleep. I'll just stop. I'll just stop.
What's the 22 prayer for next week? 22 prayer for next week.
Not next week, on the request of petitioner. Yes.
53, my lord, page 12, challenge the order of NVW, my lord. Page 12, order dated 24/1/2025, my lord. The petition earlier was on bail, my lord.
Sorry? Bail matter?
FW, my learned senior has mentioned 24/1/2024. In fact,
25,
27/9/2024. That is the correct date of order, your lordship. Kindly glance page 12, your lordship.
12, huh?
Yes. No step taken for accused person Jyoti Pradhan, present petitioner to Jyoti Pradhan, alias Kanna, alias Abhimanyu Swami, on repeated calls, hence issue NWWs against them. And against other accused person are not yet adjudicated put up on other production. But my learned senior has mentioned
You are on bail?
Yes.
Petitioner on bail. The NVW has been issued by the dated 27/9/2024. 27/9/2024. The same remain unexecuted. Hence, on 24/1/2025, the again NVW has been issued against the petition. Okay. Forgive 500. Yes.
24.
24, my lord. I am for the petitioner, my lord. Challenge the cognizance order dated, my lord. An application challenge the cognizance order, my lord.
Huh?
Challenge the cognizance order, my lord, on dated 21/11/2022. Under Annex 3, my lord.
21/11?
2022.
Yes.
Under Annex 3, my lord.
Yes.
I Quashing of the charge sheet.
Sir, I understand quashing for cognizance order. What are the grounds? You have to make out a case, not that it's a routine thing you file and pass. 22, the order was passed. What is the stage now? By now, charges and everything might have been framed. Yes,
One pass over my lord,
you have started argue. If you can't do, then I'll pass it over. No problem. Whatever you have prepared, you say.
both are the cognizance operates, my lord. My lord, cognizance operates under 341, 323, 294, 506, and 34 IPCs. Cognizance order, my lord, passed by the LD court, my lord, not be called, my lord.
Yes, yes.
My paper, both are the cognizance operates, my lord, it may be passed, my lord.
And learned friend has taken grounds that out of the charge-sheeted offences, 323 and 324 was not met out, therefore for quashment. But here is the case, the statement which is recorded during investigation under 161 statement is clearly stated the weapon of offence and injury also 323 and 324 is correctly is charge-sheeted file and cognizance taken, your lordship. I will bring the statement of lordship on the who is present during that occurrence.
Page.
Lordship. Page 26.
26.
Can glance for a moment.
Wait, let me read 26.
Yes,
Read
sir.
26. Read page 26. The complainant statement under section, recorded under section 161. Yes,
Yes.
read it.
ମୁଁ ଶ୍ରୀ ପ୍ରମୋଦ ପରିଡ଼ା ଉପର ଲିଖିତ ଠିକଣା ମୋର ଅଟେ ଆଜି ତାରିଖ 4/1/2022 ତାରିଖ ମୁଁ ଆପଣଙ୍କ ପାଖରେ ଏଇ ମୌଖିକ ବୟାନ ଦଉଛି କି ଆଜି 4/10/2022 ତାରିଖ ସମୟ ସନ୍ଧ୍ୟା 8 ଘଟିକାରେ ମୁଁ ମୋର ସାନ ଭାଇ ପଦ୍ମଚରଣ ପରିଡ଼ା ପିତା ଧନେଶ୍ୱର ପରିଡ଼ାଙ୍କ ଘରକୁ ଯାଇଥିଲି। ହଠାତ୍ ସେହି ସମୟରେ ମୁଁ ଶ୍ରୀ ମହେଶ୍ୱର ପରିଡ଼ା ପିତା ମାନଗୋବିନ୍ଦ ପରିଡ଼ା 2 ନମ୍ବର ଅନିଲ ପରିଡ଼ା ପିତା ଧନେଶ୍ୱର ପରିଡ଼ା ମୋହନୀ ପରିଡ଼ା ପିତା ଦାଶରଥୀ ପରିଡ଼ା ସ୍ମୃତିରଞ୍ଜନ ପରିଡ଼ା ପିତା ମୋହନୀ ପରିଡ଼ା ରାଜକିଶୋର ପରିଡ଼ା ପିତା ମୋହନୀ ପରିଡ଼ା ଓ ପ୍ରଶାନ୍ତ ପରିଡ଼ା ପିତା ମୋହନୀ ପରିଡ଼ା ସମସ୍ତେ ସଂଘବଦ୍ଧ ହୋଇ ହାତରେ ମାରଣା ଅସ୍ତ୍ର ତଥା ଫାର୍ସା ଖଣ୍ଡା ବାଡ଼ି ଧରି ଅଶ୍ଳୀଳ ଭାଷାରେ ଗାଳି କରି ଶଳା ମାହାଗିଆ ଆଜି ତୋତେ ଜୀବନ
Education case of state.
My lord, why the learned trial code issued the 7,000 for maintenance? On annexure 7, 63 page, my lord kindly notice. And from that, the petitioner is filed a educational application on 10th August 2022. Only for the 3 months.
Maintenance orders are generally not state.
My lord, I please. And the petitioner is appealed before the court, and appellate court the convert the 7,000 to 5,000. And from according basis, the respondent number 2 received the 15,000. So case is closed. Without filing a separate application, the in same education.
Don't bring all technicality. You have to pay maintenance to your wife. What is the big deal? 15,000, 10,000. You keep on paying. Right on. Issue notice.
And you still protect
after 2 weeks. What protection? You pay 15,000. You don't pay. What is the use? How will you settle your dispute with your wife if you don't pay this much? You have to. If you settle the dispute, you have to. You know, the end of the day, you have to pay couple of lakhs.
My lord, this education proceeding only belongs to 15,000. I will pay the 15,000.
It's all right. Keep
Then
paying.
separate application is needed.
After 3 weeks. After 3 weeks. Yes.
Stay.
Yes.
27.
Only.
Your lordship seeking time to file opposite party statement.
Sorry?
Seeking time to file opposite party number 2 statements to kindly be taken up.
Notice was issued. Press matter.
Yes, matter.
Yes.
Your lordship seeking time to file opposite party statement.
You want to file some documents?
Yes, your lordship.
All accounts for the petitioner seek an adjournment to file additional document to substantiate his case. Release the matter after 4 weeks. Yes.
28.
May I please, lordship? The petitioner challenging order dated 13/12/24 passed by Lawrence District and Session Judge Jashpur. The rejection of 457 petition in Lawrence STJM, the petitioner approach on the Lawrence District Court and District Court was a confirm this order and the release of vehicle and the petition lordship and the deluxe motorcycle. And the petition lost in accused in this case
The petitioner is the SDGM has also rejected.
Lordship.
Rejected and he
Confirmed
preferred
by
the
the
criminal revision.
Petitioner is agreed by the order dated 6/9/2024 passed by learned SDGM Jajpur, whereby the application under section 457 CRPC for release of what is that? Release of
A check deluxe
seized
motorcycle.
vehicle has been rejected. Petitioner filed a revision petition before the learned decision session judge, being criminal revision number 20 of 2024, which has also been dismissed. Confirming dismissed by the order dated judgment declared. Judgment,
Yes,
by
annexed.
order dated 13/12/2024, confirming the order of learned STJ dated 6/9/2024. Issue notice to state and Mr. Biswal accept notice. Please the matter. Yes.
29.
Withdraw. Yes, withdraw. Withdraw. 29. 30.
30.
Oh, one week approval.
The counsel for the petitioner speaks very element. In the matter of 4 to 5 weeks. 30.
31.
31. Yes,
May
sir.
please ask.
Yes, sir.
138 NIS.
Yes.
Check given by the father, retired government employee. Son is the proprietor of a, well, it's a gas company. Sales gas company.
You are the father.
No. The son owes some money to the, in business transactions to the complainant's firm. Now, check of the father has been used, who's a retired government employee, has been used to enforce the debt of the company. That is the entire case.
You have given, voluntarily given. Have you voluntarily given the check?
No, I have not voluntarily given the check. That check has been given, Your Lordship, I have given my notice.
Where is that?
That notice has been replied to.
Yes, reply.
Page 33.
Yes. Yes. What is the check amount? 5 lakhs.
5,89,000. Apparently, it's a dispute relating to some 10 lakh something. That Your Lordship finds.
5,89,000.
Right. Page 32, last page, last time. Your client Odisha Sales is having a long-standing business with Mr. Raghunath sir, my son, and there was some dispute regarding payments between them. One Gyanaranjan Parida, who is manager of Odisha Sales, has filed a complaint before the Education Commission. First, the said dispute. On 17 June 2021, based upon the court's direction under section 156(3) of the CRPC for the purpose of investigation, the Khandagiri police visited Toraba, headed by Sub-Inspector S.K. Sandha of the PS. In that fateful night, one Mr. S.K. Sandha had visited the office of Raghunath Saraf at Taraba and was verifying the documents and papers relevant to the case, and had forcefully taken to his possession the checkbooks of Raghunath Saraf, which included his father's pension account checkbook. During the course of that investigation, it appeared that your client had dishonest intention to realize his claimed amount by any means. And for such reason, your client.
No, signed check. It was you kept signed check.
Signed check, I kept in my checkbook.
Blank sign you kept it.
Blank sign, I kept it in that in my son's office.
Then you have to face the presumption. Once you sign and
Presumption of signing a check.
and
Presumption of liability is not there. Presumption of liability and presumption of check is they stand on a different footing. And this is debt owed to the company by my son. So I am totally devoted.
let us see the check.
Complaint.
No, the complaint. Let us see the complaint.
Complaint, Your Lordship will find at page 35.
Yes.
That the complaint is the proprietorship firm, right GST registration number so and carrying on its business.
No, where is the description of the?
That during the course of business, the accused Kantana Salah and his son.
His
complaint.
and his son.
Yes, that is how he has dragged him to the complainant.
I need to notice. Let us see. Issue notice.
And there's a, I was.
Is there any chance of settlement?
Yes, no, I was given a liberty by this honorable court to file an application for discharge. My discharge application has been rejected. I will try it. I'm again up before this court against this that order. So my training of charges fixed to 2nd of April. Is it not here?
Okay.
And 2nd is the day. 2nd of April. 2nd of April.
2nd April.
Fixed for training of charges.
Petitioner is agreed by the order dated. Order dated.
Order dated.
Order dated 17/12/2020.
8/10/2024.
Sorry, 8/10/2024. Passed by the SDJ first class
JMFC
3 Bhubaneswar in 160 number 2635 of 2021, whereby the application for discharge has been turned down. Earlier, the petitioner has approved the court by filing CRLMC number 683 of 2022. The coordinated bench of this court by the order dated 28/9/2022 has granted liberty to the petitioner to move the application before the trial court seeking discharge. Pursuant thereto, the application for discharge was moved by the petitioner, which has been turned down by the inferior order. Next follow. The case of the petitioner is that the son of his son has some business transaction with the complainant. And the liability appears to have been erased in the same business transaction. In connection to one of the cases registered by the opposite party, the police raided the house of the petitioner, and in that process, the checkbook for the present petitioner, who is a government employee, has been taken by the somehow taken by the complainant and being misused for the purpose of instituting the present case.
House and the office.
Yeah.
House
and office.
Office remains.
Raided the house and office and misused the office. Issue notice to opposite party number 2, written also. In the meantime, petitioner may move an application seeking an adjournment before the trial court, owing to the fact that the matter is subject before this court. If such application is moved, the same can be tensioned. Yes. You move an application.
Yes, will be adjourned.
Yes. You why don't you settle it 5 lakhs only?
Let them appear.
Shall I send it to mediation?
Let them appear. Let them appear. Instruction is that mischief.
That has been illegally dragged into this litigation to satisfy son's liability.
That's right, but the son has to pay. Why don't you pay in the installment and something you finish it up?
Well, but the first.
Technically, you keep on fighting. I take this view or that view. Again, you will go.
Case is pending before the SDM Bhubaneswar.
That I understand it. I can send it to mediation.
There the son was asked by this honorable court to further deposit rupees of 3 lakhs.
So therefore, the more of
finalization of this case.
Therefore, more of a reason that you should go for a mediation and settle all the dispute. That 156.3, this, that, everything. Why don't you?
There may be a flip side to the coin also. There may be a flip side to the issue.
Okay, let him come then.
Let them come.
Let him come.
The son has already paid 5 lakhs. The rates 5,89,000. He wants to realize the other. He has not given a single piece of paper to justify his claim.
That's a different story, but on merit, that is a different story.
If this can be resolved.
Give after 3 weeks, sir.
Can you also stay?
I have given that liberty that you move application, it will be urgent. Yes.
Adjourned.
Yes.
Great. Urgent copy of yours.
It is the matrimonial.
Matrimonial.
matrimonial dispute, matter as a amicable settlement.
I'll issue notice.
Harassment, that may be
Have you
fixed.
settled the dispute?
Well,
Already settled?
They have filed the mutual divorce petition
Madam.
before the.
Okay. Issue notice to opposite party number 2. Learned counsel for the petitioner submits that the parties have already entered into a settlement. Pursuant thereto, the petitioner number 1 and opposite party number 2 have filed application, filed civil proceeding number 84 of 2023 under section 13B of Hindu Marriage Act for dissolution of marriage by mutual consent. Issue notice to opposite party number 2. In the meantime, proceeding before so it stays.
stay of further proceedings.
Stay. Stay of further proceeding.
CP number
Further-
841.
Give the particular stay.
Have,
Stay application lekha is therefore. Stay application lekha is. Further proceeding in CT case number 13 of 2022 pending before the court of SDJM. Yes.
33.
May I please, my lord, in this case, the petitioner has challenged the order dated 14/3/2022 by drawing page 10 regarding the framing of charges. A FIR has been initiated on the basis of complaint case. My lord, may I kindly have a glance to running page 15.
15?
15.
Yes.
उक्त स्थान समय 29/4/2007 तारीख दिवा प्राय 12 घटिका समय आम मुदई शुआंशो. Then I want to draw the attention of this honorable court to page 16, second para.
What do you want to say here?
I want to say that 376 is not made out at all.
Ukto stano.
My lord.
Samay. 29/4/2007.
My lord.
Then
Then running page 16 जो एफए 1cc लॉज ହେଇଛି ସେଥିରେ ସେ କହୁଛନ୍ତି ପୋଲିସ କାର୍ଯ୍ୟାନୁଷ୍ଠାନ ଗତକାଲି ଅର୍ଥାତ୍
Yes. The ordering person is my lord is running page 16. Order dated 19/6/2024.
Yes.
The complaint case record is put up today for order of cognizance. Peruse the complaint petition, statement of the complainant submitted by way of affidavit, the advocate's notice and other documents such as checks bearing number so and so, return statement regarding insufficient of fund and found there are sufficient material to presume that the accusers committed offense and
Yes.
cognizance taken. But my only submission, if your lordship, my lord, your lordship kindly come to the cost title, my lord. Running page 13, annexure 2. My lord, he is residing beyond the jurisdiction of the my lord, trial court, my lord. Accused.
Yes.
So 202 inquiry is mandatory in respect of my lord. Not required, my lord, as per the apex court judgment, not required for evidence on oath, but they are required to submit document and affidavit on 145. That has to be filed. In case of Sunil Todi.
130. 202/130. Yes. Is notice. A similar matter came just item 15 or something.
Yeah, that is the judgment of Sunil Todi and versus state of Gujarat.
My own judgment also.
Only the affidavit is required.
Same order I'll pass.
Required.
Same order. For the order, 202 not complied. In 130.
Disposable.
Not disposable. I will issue notice and say the notice. Yes.
36.
This is a Belgium matter, my lord. The petitioner released on bail. On
Belgium.
My lord.
Okay. Release on bail on
4/9/2013.
4/9/2013.
My lord.
19/8/2016.
16.
Okay. 1,000. 1,000 each. 1,000 each.
Please, your lordship, my lord, in this application, petitioner prays for quashing of the criminal proceeding initiated against you.
Sorry?
Challenge the criminal proceeding initiated against him. My lord, initially case was registered under section 363. Subsequently, charge sheet was filed on 22/9/2024 under section 363, 366.
POCSO and all.
My lord,
So they have.
my lord, in the meantime, Gal has attained majority and marriage has already been solemnized. Both of the party amicable settlement has been made between the parties. And they are also today present
My
before
lord, I am
the
appealing for the informant. Both the informant and the victim girl and
And the
husband, they
petitioner-
are present at the court.
What is the stage of the
And the
trial?
charge sheet just submitted and the charge has been already framed.
Charge has been framed. Yes.
The marriage has been taken place on
What are the
5 to
5th February to this 25.
on the 11th November 2024, she attended the majority.
where the marriage is taking place?
My lord, Pashtuneshwar Mahadev Mandir, in which the informant was also present, and photocopies. And
What was where is this? Have you seen 164 and all?
Yes,
Just take it up.
the charge sheet. Charge sheet, the POCSO is there, my.
164 page.
No, they have not annexed 164.
I'll just issue notice getting
Yes.
because I have to record that 164 also. Recently I passed a judgment that will help
Yes,
you.
yes.
Huh?
Yes.
That will help you
Fajatin.
and do it.
Fajatin.
I'll do it. Yes, issue notice. And proceeding let the counsel for the petitioner. So entered appearance for who is for informant? Informant, who is informant?
Informant is present there.
May I please your lordship? My lord, I am the adjournment for the matter.
You are not visible. Adjournment, huh?
So we have on behalf of Mr. Panda.
Okay. On behalf
May I
of
please your lordship?
Panda, Mr. Amulya Ratan Panda.
Yes.
Adjournment is sought on the ground that Mr. Panda is not disposed. Indisposed. Indisposed. Please be noted. Yes. 39.
On behalf of Raghunath Das Mahapatra, as he is not feeling well, can you kindly post this matter to tomorrow or day after?
On behalf of Mr. Raghunath Das Mahapatra, there is an adjournment is sought on the ground that he will take disposed. Please be noted. 40.
May I please address? My lord, here in this application, the petitioner has challenged the order of taking cognizance dated 5/12/2024, my lord. On the ground that, my lord, my ground number, at para 8, my lord. The petitioner, while traveling, had lost the checks for that, and he made a affair at
Then you have to prove
PS. My lord, annexure 3, my lord, page 16.
that.
Page 16, my lord.
Yes.
As the checks were lost, he made an station diary entry.
When?
My lord, page 16.
When?
On 27/3/24.
27.
SD entry,
24. Okay.
27/3/24. And the said check that is issued, that was alleged by the OP2, my lord, 25/7/24.
25.
7. After 4 months, my lord. 3 months.
These are the disputed facts to be settled in the trial court. How can I believe that report to be true? It has to be, you have to summon the witness, examine whether, see, this kind of missing report can be managed anytime. If you want, I can do it. 2016 also, I can prepare this document by paying something to the police. How do I know this? This can't be, there is a missing report only. There is no FIR, nothing.
My lord, FIR, my lord, that was because it was not properly visible.
So
for
this
that,
has
I have not annexed it.
Those things has to be proved on record. Nothing can be done. What is the check amount?
Check amount
25 lakh. 25 lakh.
Huh?
25 lakhs.
Then it has to be proved. You can't, very simply. Let us see the complaint.
Well, as the complaint is that the petitioner borrowed 25 lakhs from him for business purpose and promised to pay, return it within 6 months. Thereafter, he did not return. On repeated request, he issued him the check to the OP2.
Then
and that was bounced.
Where is your reply to 138 notice? if that was the case, you have lost your checkbook and all.
My lord.
In the 138 notice when you got, you might have said those things. If you have not said, then you might have created this.
Well, that document I will file as an
No,
additional
I said
additional
that.
evidence.
Unnecessary, you are trying your luck by not, so you see your file, it must be there.
No, my lord. But not in my lord.
Then see,
that is reply, my lord.
Page 11 and read it. That accordingly, on 3/8/2024, the complainant deposited the above checks also. Read it. Thereafter,
My lord, pardon, my lord. 11.
Complaint petition.
page 12, first paragraph.
Page 12.
So the notice through his advocate and which has been received by the accused on 11/9/2024 and on 13/9/2024, the accused replied through his advocate by denying the fact and took several
Contradictory pleas which are not
Then you have
satisfactory.
filed the reply. Show me the reply.
My lord, that I will.
Learned counsel for the petitioner seeks an adjournment to place on record the reply he had furnished to the reply he had given to the legal notice issued by the opposite party complainant on 11/9/2024. Leave the matter up to yes. 41. You have replied, then you must, that is the whole case. If you have said that, then you have a case.
I should have annexed that.
Then 139 will not operate because you the first available opportunity you have denied. And the onus shift to him now.
My lord. That reply I should have.
The burden of proving is shift immediately because the rebuttable presumption. If you don't reply, then presumption operating. Once you reply,
then
the burden shift to him.
I understand.
That's the whole case. File it immediately. Yes. 41.
Matrimonial matter. 498.
498
My lord.
Issue notice.
File.
Issue notice. 42.
42, my lord, permitted to withdraw.
Withdraw. Very good. Withdraw. Very good. Very good. 43.
May I please, Your Lordship? Your Lordship, the petitioner is seeking for the quashing of the criminal case which is pending before Learned District and Session Judge Sambalpur, Your Lordship.
Yes.
Lordship, here the brief fact of this petition is that, Your Lordship, the petitioner, kindly see para number 3, page number 3, Your Lordship. Petitioner is a registered owner of the appertaining land which is situated in the Sambalpur and Moja Padiapalli. Khata so and so, plot number also so and so, and area AC 0.15 decimal, Your Lordship. In order to meet his legal necessity, he wants to sell his land, Your Lordship, but not above the land which I have mentioned in the para 3, Your Lordship. And also accordingly, the opposite party came and they have decided to sell the land. Your Lordship, purchase the land, and also, Your Lordship, the amount was also fixed. And later, Your Lordship, the opposite party also he has given him such kind of the amount, and also after later on, he repudiated for the same and didn't pay the amount, Your Lordship. And again, rather he said to the petitioner, that
what was the consideration?
90 lakhs.
90 lakhs.
How much you have taken as a advance?
62 lakhs.
62 lakhs, Your Lordship. Yes. So, Your Lordship, the land which is I have mentioned in para 3, that the petitioner does not want to sell that land. And Your Lordship, the opposite party here, Your Lordship, the opposite party is the influential person, is a government servant. And by taking of that advantage, he, with the help of the local IIC and the SDPO, he, Your Lordship, he tried to threaten to the petitioner to sell the land in his favor, Your Lordship. Which land I have mentioned.
Show me the agreement, whether in the agreement, whether you have written this land or somewhere.
Your Lordship, that agreement I don't have, Your Lordship.
That's the whole case.
Yes,
if you
Your
say you have taken advance to sell some other land,
yes, Your Lordship,
and they are now forcing it to sell another land, another piece of land, the agreement will speak.
Yes, Your Lordship.
Your entire case is on the basis of agreement. Show me the agreement if you have.
Your Lordship, I have not annexed that agreement.
What are you making out?
Your Lordship, kindly give me some time for annex this agreement, Your Lordship.
Why should I entertain this kind of petition? I don't understand. Your entire case is based on a particular document which is not there in record. Why should I entertain? Why you are wasting court's time like this? Your whole case is 66 lakhs you have taken. Sale
Yes, Your Lordship.
consideration is 90 lakhs.
Yes, Your Lordship.
66 lakhs you have taken
Yes,
as
Your
an
Lordship.
advance money to sell X land.
Yes, Your Lordship.
Now the purchaser says that in lieu of that transaction, you sell it B land.
Yes, Your Lordship.
That's what the case is.
Yes. Yes, Your Lordship.
The agreement, show me if the agreement, if this is not written, then I can interfere. Otherwise, there is no question of interference.
But Your
Simple.
Lordship, but Your Lordship, falsely the FIR has been registered against me. Your
No
Lordship.
false,
There are
correctly written. Read the FIR. Read the FIR. Read the FIR. Read the FIR and tell me which is the land you have entered into agreement. Where have you said in the your petition
yes,
that which is the land you entered?
I'm reading.
Huh?
माननीय श्रीयुक्त भारप्राप्त थाना.
No, you show me in your petition
Yes, Your Lordship.
that you have agreed to sell X land, whereas he is demanding to register Y land. Where have you said that?
Paragraph
Lordship,
Paragraph
in the paragraph 3 only, Lordship, I have mentioned the petitioner is only the registered owner of the.
Then it is more of a reason that you face.
Your Lordship.
Then you want to you have taken advance to sell a land which is not in your favor.
So, Lordship, the matter may be taken on either. My learned senior is not here, Your Lordship. Please, Your Lordship. So that
You are arguing so well. Why are you?
No, but no, Your Lordship.
Why didn't you argue? No problem.
Your Lordship, whether the question before this honorable court is the agreement, Your Lordship, the I have
What exactly? What has happened is
yes, Your Lordship, I am not annexed this agreement, Your Lordship. The kindly matter may be taken on it.
deliberately it is not annexed. I know that. You don't have a case. If you annex,
No,
you are out.
No, Your Lordship.
You don't have a piece of land. You have taken the money to sell that land. And now the complainant says that now, since that land is not with you, you sell your own land, this Para 3 land. That's what he says. Read the complaint.
Lordship, I have read, Your Lordship.
Either you say refund the money or give it this land. This is the only option.
Lordship, only one date, Your Lordship. Otherwise, I will misunderstood by my senior.
Because you are arguing so well, you should substantiate your case.
Thank you.
Anyway, he is yet to prepare. You prepare and come. You prepare and come.
Oblige.
Okay.
It's a 3 SCST matter, my lord.
Young man, he's
My lord, can it be noticed to the opposite party? Because 3 SCST.
3 SCST.
It is duty bound to.
Okay.
My
Then
PACST, Your Lordship.
I'll just simply issue notice, let us see.
Right.
Issue
Yes,
notice.
Lordship.
Okay. Issue notice.
44.
Have you implemented him or not?
Yes. He has.
Has he implemented?
I have tried.
Okay, issue
Yes.
notice to opposite
Yes,
party.
yes.
So, Mr. Ponda, I take notice of it.
Highly obliged.
Yes.
May I pray next week, my lord, item 44 on behalf of Sarma. On behalf of Sarma, kindly taken up next week.
On behalf of Mr.
Next week.
Sharma.
Timely.
Yes,
and
yes.
Sharma.
Sharma?
Yes, and Sharma.
Request, sir. Wait, okay, adjourn.
May I please? My lord, here in this case, my lord, the learned court below was not pleased to take cognizance for the offence punished under section 13(2) read with 13(1)(a) of the PC Act, my lord, along with other offences. Though he was pleased to take cognizance for IPC offences, but was not pleased to take offence for the PC Act offences.
Who are you?
My lord, I am the complainant. My lord, in
Let the state come, why are you worried?
because my lord, there is
PC Act,
there is
just informant.
there is ample evidence that
He has lost complaint. Thereafter came in a CRLMP. This honorable court directed to lodge FIR. Thereafter, FIR has been lodged, investigated by the vigilance people. Vigilance people found that it is not a case of PC Act. Thereafter, they have not.
though the government servant for giving in the office in my phone number and the electricity of the authorities are demanding me
Why
for
are
that,
you after him, Mike? You tell me.
because the OP2 by giving the phone number of me taken a loan from the government and to run a pump set and the electric bills he has not paid. The electric officers
Therefore, the charge sheet has been filed.
My lord.
My lord, who is for the pata?
468, 471,
My lord.
420, 120B, everything.
But my lord,
Where is the PCS?
but being a government servant, he forged my documents to take
Is it coming under the purview of the color of duty?
And this is a corrupt practice, my lord.
No. Corrupt practice for the purpose of public. He has committed an offense outside his official duty. So rightly not taken.
My lord.
And 468, 471, you concentrate there. If you can convict, you can convict. Where is the question of prevention of corruption? Where is corruption? It is outside.
But he has availed pecuniary gain from the government because by forging my.
No. The forging, therefore, 468, 471. Serious offenses.
One thing I pray, my lord, I will raise this point before the learned court below. At the appropriate time.
To withdraw the petition to raise all the points before the court below. The petition is withdrawn with liberty. Yes.
May I please your lordship? My lord, the prisoner challenged the order 4/10/2024.
Belgium, my lord.
Belgium. Date, give the date.
My lord, Bell 3/3/2005. NBW 4/10/2024.
2020.
2024, my lord.
2024.
NBW.
Yes.
47. May I please your lordship? My lord, the prisoner challenged the order passed on 4/10/2024, passed in SC.
That Belgium matter.
Another matter.
No.
That I will allow, sir, your matter. 47. Yes. I will allow your. Yes. 47. Yes.
47 can take no next week. Next week, right?
Now, why?
My senior is arguing this matter.
Mr. Sahu, on behalf of Mr. Jyotirmay Sahu, counsel for the petitioner, adjournment is sought on the ground that he is not well. Please the matter after 4-5 minutes. Yes. 48.
Belgium matter, Belgium.
NBW issue 27/2/2023.
Anticipatory bail 7/9/2012.
7/9/2012. And NBW issued on
27/2/2023.
23. Okay. 500. 49.
My lord, in this case, I have challenged the order dated.
Recall to POCSO victim.
POCSO victim, my lord.
Yes.
In this case, already opposite party number 2, my lord. And filed this application for quashing the order dated 4/2/2025. That is
who is PW8?
PW8 is victim, my lord.
Victim.
Victim, my lord.
Yes. Where is her statement?
My statement not filed.
Where is your statement? Evidence?
Yes.
Where is it?
Ashin. PW8.
PW8, huh?
PW8, my lord.
How will you get over para 17?
My lord, at present, my humble submission is that, my lord, at present, she is residing with the petitioner family, my lord. And both the family members settled their matter and they were willing to marry the victim and the petitioner, my lord. And
want to marry victim and petitioner?
Yes, your lordship.
Where have you said those things?
That is in para 4, your lordship.
In the application, where is the application? 311 application.
Para 6, your lordship.
Para 6 of your application?
Yes, your lordship. Para 6 of my application. I have read that it is respectfully submitted that the petitioner.
No. The application is consisting of only 4 paragraphs. 311 application I am talking about.
The lower court advocates.
Only four paragraph.
4 paragraph
You have not
settlement.
said anything.
Only love affair settlement.
Law affairs ଉପରେ ସେ discuss କରିଛନ୍ତି.
Do not want to proceed with the case.
I'll issue notice.
Compromise.
I don't know.
Right.
Issue notice. Because you have asked, the trial court says that you have all asked question number
Asked
1
the
to 5, you have already asked the question, not
Right.
relevant.
Right.
And 6 onwards, all the questions are already put to him,
Right.
put to her. Okay, issue notice. Yeah, next.
My lord, in which case is the till date, my lord?
I told you.
It is a Belgium mail 16/1/2018 NBW and anticipatory mail 30/11/2016.
Got it? Solo.
16/1/2018
DW and the bill
30/11/2016.
30. Okay. 1,000. 1,000. 1,000 each.
51 here, my lord, petitioner challenging the quashing of cognizance was issued 2013, my lord. Here, my lord, the petitioner case is that while he was working as a land acquisition officer, he purchased some land before land acquisition in the roadside, my lord. And thereafter land was acquired, my lord. And he belonged to ST category. The land also purchased in the ST category. This is the allegation, my lord. And this case is pending since 2013, my lord. Annexure 2, after cognizance order, no step has been taken, my lord. And I have filed the allegation under Annexure 3, where the land is mutation appeal was made, and in the mutation appeal, no irregularity was found, my lord.
Mutation appeal will not decide. Yes.
There cognizance order, they are challenging 2025.
That's right.
As must have been proceeded by.
My lord.
Report.
This is the only ground you have.
Only ground, my lord.
Except that there is nothing.
Nothing.
Petitioner is seeking quashing of the order dated 19/8/2013, passed by learned special judge
Vigilance Sambalpur.
Vigilance Sambalpur, huh?
Sambalpur.
Vigilance Sambalpur, whereby cognizance of offences punishable under section 13(2), read with section 13(1)(d) PC Act, read with section 420 and 120 IPC has been taken against the petition. The counsel for the petitioner submits that although the cognizance has been taken in the year 2013, but the trial, thereafter the trial court has not proceeded in inch. Even the charges have not been framed. In view of the regard being had to the statement made by the counsel for the petitioner, I feel it appropriate to sought for a report from the special judge vigilance regarding the status of the trial in CT case CTR number 26 of 2030.
Cause of delay.
And mention call report regarding the delay in
Item 41 malware says issued notice. It's a 492 case. Petitioner is government servant. I filed one.
It's a 41 notice, na? 498 application for exam. Yes.
Stay up about it. 52.
Yeah, the petitioners are the employee of a company, two companies rather. They have been implicated under Annexure 1 by the government official who is a DSW OP number 2. For their bid was rejected, then they were declared as disqualified in the Jim bid meeting number. So that is indicated in the FIR, for which they intended to meet her in the chamber, and some of the associates of that company took some photographs. of the DSW. That is the reason she wrote a letter to the IIC concerned police station for reason this FIR is registered. Subsequently, it is now.
Investigation is going on.
No, well, it is compromised. She has no, she is no more interested to continue with that.
Notice to
Informal.
be issued, Annexure 2, my lordship, kindly have a glance, page number 14.
14.
Yes, there is
Affidavit.
yes, there are compromise affidavit they have filed.
What are the discussions about the discovery?
She can appear through because she is a government servant. Nothing happened on that day. Only for rejection they had gone to discuss about the issue.
She cannot move on the private for new area and consulting association for presently complaints about the disqualification. Oh, in the office they have created all this problem.
Yes,
Issue letter.
yes, notice to be issued.
Issue notice to opposite party number 2. Opposite party number 2 is the DSW.
Yes,
Yes.
DSW.
DSW. Be ready to pay heavy cost.
Yes.
Because this is the behavior.
Nothing has happened. In fact, nothing has
Product-
happened. Only the photograph they had taken, the meeting.
What
was discussion?
Her and
If your lordship see the letter, there is no criminal act.
These are Gundaism, nothing else.
They are
You can't
taking
do
only
all this.
photographs about the discussion
And
going
you
on.
harass a police officer, a senior officer like this because
Rejection of the bill.
this is not acceptable. You should I'll quash it, but subject to you know what.
As your lordship.
Issue notice.
I am taking notice. No coercive action because we have not moved for bail.
You have to settle the dispute. Then I will. What is the stage now?
Investigation is continuing.
I don't know what is the stage.
They have not filed anything.
You have not said anything.
Yes, my lordship.
The FIR is
Kindly-
registered.
Just only FIR is registered.
CD call for so that we can get the.
Call for CD.
Because magistrate tribal offense, all are magistrate
Let's see,
must have been
let's
completed in the
After
meantime.
2 weeks days old. Yes. Nothing is about.
No question.
No, after 2 weeks I'm calling because November 2024 the FIR is
Yes,
registered. Nothing has happened.
Well,
What is
listing
going on?
number,
Nothing.
we have filed immediately the case.
Not immediately. When have you filed?
Case we filed on January 25.
January it is not necessary. Thank you, sir. January matter is nothing.
Another matter I had
So
also.
I am listing all the matters which are not listed at least once for these 3 days.
I am looking to the list
Only
also.
all the matters at least they should at least once the matter should be heard. That's the reason. Yes. We'll see. Yes.
Hon'Ble.
53.
Please, my lord. My lord, I am appearing for the petitioner. The application is for quashing the criminal proceeding relating to GR case number 1032 of 2024 on the basis of settlement agreement, my lord.
What are
Kindly
the
have a
offenses?
glance to my lordship, page number 18.
I am for the
18?
18, yes.
I am for the appealers.
Yes. What are the
They
legal?
want to settle the dispute because there is a monetary transaction, my lordship. And in page 18, kindly have a glance, my lordship. After 10 line, my lordship,
Yes.
the informant victim of this case has personally appeared in the court and submitted that the matter has been amicably settled between themselves and he has no objection if the accused petitioner is released on bail. He has also filed an affidavit on to that effect. For that, they want to pause this petition. To file this. Yeah,
Okay.
right. My lordship, no.
It's a 307.
Yes, my lordship, but I have not filed anything.
Injury simple.
Yes,
That's what is the finding.
yes, yes.
My lord.
Sustain simple injury
Yes, my lord.
on each person. Okay, issue notice to opposite party number 2.
Lord, sir, I am for the OP.
Yeah,
Lord, sir, I fixed a date. You will appear.
And call for safety, my lordship.
Also entered appearance on behalf of opposite party number 2 on advance notice. Mrs. Marana accepts notice for the state. Then counsel appearing for petitioner and opposite party number 2 conjointly submits that the parties have entered into a settlement On the basis of the settlement terms, the present petition has been filed. The request for an adjournment so that the party would appear before the court. Please the matter on, please. Yes.
This is arising out of a civil dispute between two brothers, my lordship.
Two brothers.
Yes, my lord.
What are the allegations?
My lordship offense under section 126(2) to 96.
Hey, what are the allegations? Don't read the section.
So regarding one land, piece of land, and he is saying that is my land, and there is a settlement also by the civil court, but still they're fighting for the land, my lordship. For that, they have given the affair.
Then I'll
One
pass
of
it
the
to
brother,
let
yes.
them. I'll take it up on the other matters. Okay.
It's like Bharatpur police station matter. It was
Mentioned in the morning.
I will be pardon your lordship, item 119 is a compromise matter. Both the parties are there. So
I'll take it up. I'll brief there.
last item, your lordship.
Yes.
Here is the case. Your lordship has already had the matter extensively. The fact remains the present petitioner, namely Prashant Jain, he belongs to Delhi, my lord. The background of the case is, my lord, the affair is lodged by one T. Rameswar Rao. He has stated in the affair, present petitioner is not named the affair. He has the T. Rameswar Rao from Koraput. He had a land business. He has lodged the affair with the allegation that in October 2023, he had come with contact with one Subhranshu and two others to purchase some land. So he had come to Bhubaneswar. He had given advance to the Subhranshu 10 lakhs. Thereafter, they had gone. On date of occurrence on 17/2/2024, after 5 months, the present petitioner, he had come for a darshan, Lord Jagannath, Mr. Subhranshu, he has taken care to take the Puri. Thereafter, they had been gone to Jotni to show the land. That is the only allegation. Last occasion, Lordship wants to know the allegation, what is in the charge sheet, my lord. Charge sheet already I have filed. I am reading the charge sheet portion, my lord. Lordship may kindly have a glance.
Yes.
The state was directed to produce the CD.
No, CD is there. Charge sheet already I have.
Let us see the what are they.
Charge sheet is there. I am reading, my lord. Charge sheet.
Yes.
Here, my lord. That on 7/2/2024.
After the relevant partner.
Yes, so and so. Say Rameswar Rao, Menur Koraput, so and so reported in writing to the effect that he is dealing with the real estate land business, so and so during the month of October 23, my lord. So 5 months back, there are a dealer. He came in contact with one Subhranshu Shekhar Parida, who introduced Narendra Kumar Sahu and Virendra Kumar Panda as a land broker, who are dealing the land business in Bhubaneswar. Thereafter, Subhranshu Shekhar Parida, along with Narendra and Virendra, show some pictures of the land near IIT Jatni. After that, all of them told them they have 2 acres of land near IIT Jatni. They will sell all at price of rupees 1 crore per acre. Subhranshu, Virendra and Narendra demanded the complainant to pay 10 lakhs and advance. After going through the legal formalities and paperwork, very soon the owner will register the land. They show me some
photocopies of the land and some sketch maps of the land. They told me the status of the land, Sthiti Bank. And when the complainant asked about the ownership of the land, they could not give any papers of the owners of the land.
Where are the statements?
Statement, my lord. Statement of the complainant, my lord. I'm reading, my lord.
Where is that?
That he has also not complained anything, my lord, against petitioner, my lord.
Yes, show me the CD.
Yes.
That is why I am praying. You should take it after 7 days. Because
You have not placed on record any document.
Yes, my lord.
Any document except the first 2 pages of charge sheet. Where are the statement of the witnesses?
Just when my last occasion, CD has come. Lordship has had the matter. Thereafter, asked the government council that that is already there in the record. Absolutely.
This matter is pending. See, 1, 2, 3, 4, 5 hearings has taken place.
Already CD is there. It is only on Jotney, my lord. CD is there. My friend has.
Cognizance is taken.
Cognizance. Cognizance, my lord, because charge sheet has been filed. I don't have any instruction. Your lordship want to know what is the allegation against him.
Yeah, the allegation is all right, but unless I see the entire charge sheet, how will I form a
Charge sheet is there already.
Only first 2 pages.
Entire
Charge
page.
sheet doesn't mean that the extract of the case.
I'll file
all the statement of 161 statement.
That my friend.
The documents.
I'll file, my lord. I'll file all the ones.
You argue all these things at the stage of move an application before trial court. Trial court
Lordship,
look into
lordship,
it. Why should you look
keep
into
it to next week. My friend has not the case diary.
Why have you filed selected document?
No, I have only filed, my lord, quashing of the proceeding because I don't have any.
Can I quash the proceeding?
In respect of the petitioner.
Charge sheet is filed without looking into the charge sheet?
Yes, lordship may keep it to tomorrow or after election. I am contesting election.
5, 6 hearing you have taken only for that.
Election I am contesting, my lord. That is why I pray.
Chalo, you concentrate there. That's better. Okay, least up to it. Okay.
Obliged, my
lord.
I'm appearing in this case, your lordship. May I please, your lordships? This is quashing of the FIR. I stay in Delhi. I am the director, executive director of a NGO, my lord. And our work is basically welfare of the marginalized communities. Marginalized communities. Now, we had taken up this informant in our profile. On probation basis, during probation, he was dismissed.
Yes.
Because of some incident which are not relatable to his job and complaints we received from different quarters, basically the young mothers and our employees. So Annexure 2, page 17 is this order of disengagement. Soon after this, he comes up with a FIR filed before the Nayapalli Police Annexure 11 under section 296. 296 will be equivalent to obscene words and all that. 324.
The investigation is going on, it seems.
It is a FIR. I have come for FIR also. Plain reading of the FIR.
But let the investigation. I don't know what.
No, your lordship may look at the FIR.
A FIR case may not be made out, but the investigation has to.
My lord, prima facie on plain reading of the FIR, that Haryana case, your lordship, that famous case. If a case is made out, then we can wait for the charge sheet.
If FIR is being quashed at this stage like this, the moment FIR is filed, you come and say that read the FIR, no case is made out.
I am not saying that. I am not saying such things, your lordship. I will take your lordship.
See, the FIR is registered on.
No, I am not saying those. I will take your lordship. I will take your lordship to page 14. What he says in against me, basically allegation. What is against me? The following evening, towards the top, my lord, page 14.
Yes.
The following evening, I attempted to report this caste discrimination to Viraj Patnaik, explaining how IPSA Pratipadma Sarangi had restricted my use of public facility and threatened me. However, he dismissed my concern and left the training venue at Chhatrapur without addressing the issue. This is one of the allegations against me. And then the third paragraph towards the end, I sought a meeting, third line, my lord, I sought a meeting with Viraj Patnaik on November 23rd, 2024. However, he ignored my concerns for 40 days and dismissed my grievance in a brief 10 minutes meeting stating that I was solely accountable to IPSA such and such Sarangi. These are the two allegations on the basis of my name appears in the FIR. And can these be constituted under any of the provisions by law 296, 353, 24, 351, 35 and SC/ST Act?
Let it be investigated.
Let notice go, your lordship. I am not asking for.
Is there and you see, is an exhaustive
Yes,
claim.
your lordship,
Exhaustive
kindly,
claim.
when you not look at the FIR, such a big FIR, it is framed FIR. Lordship, I am not seeking for any interim order. Let notice go to the complainant, informant. Nothing is against me except these two sentences, isolated sentences. I didn't address the issue.
No, you have to read the complaint in entirety,
Yes,
not
my lord.
abstractly 2 lines
After
somewhere.
reading the entire thing, this is the only 2 lines.
Kind of treatment meted out to the complainant. He says that these are the people, those who have done it to me.
He is not saying that also. The entire blame is on that Sarangi.
I'll just issue notice, Lala.
Yes. I am not asking for any interim review, my lord.
Yes.
21. I filed the APNS one. 21.
Quashing of order for discharge petition is rejected. That is under the challenge of offense under section 376. Only on the ground, the statement recorded under 161 is twice recorded. First, the victim has not stated against the present petitioner. Secondly, the victim has stated against the present petitioner. That is the ground for crossment of the charge.
What about the other
Evidence.
evidence?
That so far the order input herein only against present petition that was rejected. Petition for discharge.
No, what are the other materials against him?
Only
If that 161 statement is
no, that statement is not here in this brief. That is not annexed in this criminal investigation.
That's the whole difficulty.
Only affair and charge sheet.
Where is the ground?
That is your also input notice page 42.
Now, where are the grounds? Look, where does he say that the secondly?
Can be answered for 42 also in that 25 1 and 25
42. So nobody is appearing. Nobody has appeared for petitioner, even in the second call, in the interest of justice, scheduled to release it in June. Yes.
54.
54. Yes. Yes. Yes, 54. What is this matter?
My lordship, it's arising out of the civil dispute between 2 brothers, my lordship. There is a affair and a counter affair.
Counter affair.
Yes, my lordship. Before also there was a affair where the petitioner was acquitted. And again, his brother filed another affair. My lordship, page number.
Okay. Brother, I'll issue notice. Huh?
Yes, my lordship. 2 brothers.
Issue notice to opposite party number 2. Release the matter of person.
55.
May I please, your lordship? Quashing of inter-criminal process.
For the petitioner, in the second call. However, regarding that to the facts of the present case and the fact that the petitioner and opposite party no to our brother, issue notice. Yes.
Madam, quashing of inter-criminal proceeding on the ground of a compromise matter. The petitioner is the father of the main accused. The son of the main accused, cognizance order, annexure under annexure 3 matter at page 21, 24 matter. 24 already quashed by this honorable court matter.
24.
Matter?
24.
Page 24.
This is the.
This is the main accused, son of the offense under section 363. He already married and blessing with 2 children, my lord.
Issue notice to party.
My lordship, kindly have a glance to page number 23.
23? Yes.
Last paragraph, during course of investigation as the prime facie evidence under section 363, 376 IPC well made out against the accused Pimple Raj Naik. What my brother is saying about the Pimple Naik.
No,
yes, and son of Sibul Ranjan Naik, and under section 341, 294, 506, 109 IPC well made out against the Simple Raj Naik, and what he has done, my lordship, In the first paragraph, it was written is that on 21/4/2011, 6:30, complainant Ravindra Naik of the village Aligada, Gajapati came to PS and present a written report before the IIC above, alleged to effect that one simple Raj Naik, who is the present petitioner, residing at the Aligada, came from the Kandhamal district and created havoc in the locality and took 407 vehicle and in a lease and basing on the beside paying the amount of the owner at about the 12 months and threatening him to kill, my lordship. For that, my lordship, this
No, what are the three?
his offenses 341, 294, 506, 109. His kidnapped the daughter.
Kidnapped the daughter and
Married. And for that he has come to before this honorable court in CRLMC, and there also he has not made a party to his father, my lordship. Kindly have a glance to the CRLMC Annexure 3, my lordship. His father is saying, I thought that this CRLMC is connected to my case, and my case also.
It's a different case also.
No, my lord. No, my lord, it is the same case. Kindly see page 21, my lord. Charge sheet filed against the present petition 341, 294, 506, 109, 5, my lord.
It's different, my lordship.
The offenses are different here.
Yes.
No, my lord. Same affair, my lord. Kindly see page 12, same affair. Same affair. The main activity is sure, my lord.
506, 409.
So, man, can you keep it more, my
Charge sheet, how many accused were there? Let us see. Accused.
Simple Rajrank and Simple Raj.
Two,
my lord. The father and the son.
And what is this then? Annexure 3.
Annexure
3 is the question already the cognizance of the son.
This is
Son.
376 and 509.
My lord. Annexure 3 cognizance of the son of the petitioner already classed by this honorable court, my lord.
Okay. The mother, she's no.
Father.
He is the son, my lord.
Prutanjali Naik.
That is the wife of the daughter-in-law of the present petitioner. Bahutara.
Pimple Raj Naik.
Pimple Raj Naik wife.
And Simple Raj Naik is the brother of
father of the Pimple Raj Naik.
Father is a simple Raj Naik.
Petitioner is the father, my lord.
Party to this. Ravindra Naik's daughter is
okay, let us issue because the part of the
Yes.
FIR.
Man, can keep it to tomorrow the informant and the
No, issue notice us. Yes. Next. 6. Yes.
Notice to be issued, my lordship, opposite party 376 2N is there, 506 is there.
Notice.
May I please before your lordship? My lord, here in this case, I am challenging the order of taking cognizance 363 and 305 of IBC, my lord. In this case, your lordship, on 17th, my lord, the informant's daughter fled away from his house and he is lodged affair against one Sunil Kumar Sahu, the present petitioner, is the Saroj Kumar Raut. My lord, the daughter's mobile number was also there. During course of investigation, I also CDR of the mentioned in the charge sheet in 2 numbers, my lord, from 15 August to 20 August, my lord. On being suspicion on 24th August, the present petitioner has been arrested and seized the mobile number and another number. That also not the CDR has not been. And the postmortem report, the charge sheet, your lordship has page at glance 26, my lord.
What are the offenses?
305 and 363. 363 is not made out. He has fled away from the house and Sunil Sahu name is there. In the present petitioner has been arrested on 24 on basis of the statement of one Pinky Raut. The present petitioner has been implicated and the SIM number is not, the CDR is not available against the present petitioner. And in charge sheet, police has mentioned, my lord, the present petitioner denied to marry her. For that reason, the victim did not return back to the house and committed suicide by jumping inside the Brahmani river.
You are?
I am Saroj Kumar Raut, my lord. Affair, your lordship have a glance, my lord, at page 7.
Why should it be quashed then?
Well, there is no material lateral against the present petitioner. Your lordship call for the
material which
CDR.
are there, the material which are there, you have not filed.
Yes.
Your lordship.
Selectively you filed the documents.
See-
Where are the statement?
Police has
Where are the statement 161 statement and other material?
161
You
on the.
don't file the materials before this court. That doesn't mean that you that is
Your
not
lordship,
there.
I presume that your lordship call for the CD, my lord. For that reason,
No,
they
you
rely on the police.
It's not a routine thing. You file an application without.
I am also a certified copy of the Pinky Raut. I have also.
You file it if you want to.
Yes, I will file.
Substantiate the case.
Yes, I will file, my lord.
For the petitioner, seek an adjournment to place on record additional document to substantiate the case. Let him do so within a week. Release the matter after 3 weeks. Yes. You can't file the selective document and withhold the real document on the basis of which the.
But I am also stated in my petition.
But you
also.
filed those documents, 58.
My lord, in this case, the petitioner as informed lost the affair on 14/3/2020. Since then, filing of affair, charge sheet has not been filed. Investigation is going on. We are challenging the inaction of the police, my lord.
Yeah, my lordship, their prayer is to direct the IO to submit the charge sheet and FND after completing the due investigation. From 2020, they are saying that
Since 2020 is pending.
no investigation has taken place or charge sheet is filed.
2020 FIR.
My lord.
So cyber.
What are the offences?
420, 419, 420, 465, 468.
So 2000,
My lord,
the investigation is going on in 20. See the proceeding.
My lord, upon
See-
the
See the proceeding. Proceeding dated 1/8/2024.
my lord.
This case is put up today. The IO submitted the progress of the investigation report and put up for awaiting final response. And that is on 1/8/2024.
My lord, 1/8/2024, my lord, upon the petition of the prosecution, I filed progress report, my lord. Khali, but the culprit could not be traced. My lord, account, there is a sufficient address and identity of the.
It is a cyber crime, my lord. So
Yeah?
it is cyber crime. 86,000 has been taken by that
Right.
person. So
Cyber crime, nothing happens.
my lordship can
जो
direct.
टेलीफोन नंबर भी से फोन करथिला accused person ताकू भी ट्रेस करना दी ट्रैकिंग करना किछि भी करना
What is the amount involved?
मान लो 84,000 5,000 84,000 something.
I will just record that you should expedite it, that's all.
Yes,
Right.
yes, my lordship.
ମାନେ टाइम टाइम ଟା ଟିକେ
हाँ, ସେଇଟା
Understand.
कर ସେଇଟା କରିଦେବେ।
Petitioner is the informant in the FIR number, PH case number 24. The investigation in the present case is still going on. And then the petitioner submits that although the FIR was registered on 14/3/2020, but the investigating officer is not proceeded with the matter and filed response as yet. Therefore, he has approached this court for a direction to the investigating officer to conclude the trial. Regarding head to the facts of the present case and submission made by the petitioner the bar. I'm inclined to direct the IO to do it to see that the investigation of the case is completely possible, right? Possible, and file report under section report first of the sign form under section 123 CRPC. This obligation is
May I please, my lord? May I please, my lord?
Yes.
Item 59. Quashing of the cognizance and issuance of process, my lord, filed by the petitioners, wherein petition number 1 is the complainant on the basis of compromise. The agreement is at Annexure 4 and cognizance was taken by Annexure 3 series page 27, my lord.
Yes.
And the offences are under section 498A, 323, 506, 4 DP Act and 67, 67A IT Act.
I'll issue notice. Issue notice. Huh?
My lord, the
Matrimonial.
Yes, sir.
complaint is petition number one.
But have you implemented the informant? No.
Informant is the
Petition number
petition.
one.
Sorry?
Informant is the petition number one.
Petition number one.
It was a joint application filed. my
Okay,
lord.
okay.
They
Settled.
filed an agreement, annex, white annexure 3.
Okay.
That's it. my lord.
Page number 31, annexure 4, page number 31.
Where are they?
If your lordship will fix a date, I will make them appear, my lord.
Second. Second. The petitioner number one is the informant.
Yes, my lordship.
At the instance of petitioner number one, the FIR number came to be registered against the other petitioner. The dispute is arising out of a matrimonial dispute. The parties have settled the dispute and reduced down the terms of settlement by way of an agreement. Reading of the agreement dated 3rd February 2025 reveals that the petitioner number one and opposite petitioner number one and two are now revived their conjugal life, and they are happily residing in the matrimonial home. The petitioner one is happily residing in the matrimonial home. Therefore, a joint petition has been filed for Quashing of POCSO. Leaves the matter on certain practice for appearance of the petitioners. Second. Yes.
In this case, I am challenging the cognizance order passed by the law Division Khurda, my lord. Here, a matter the arising out of the complaint case, my lord, and that complaint is the my lord, the mother-in-law and other is the daughter-in-law and the relation lordships.
Yes.
And my respectful submission, my lord, that the allegation against the false and my lord the cognizance is my lord not prima facie is made out, my lord. Here, categorical statement, my lord, in the 1 case, my lord, एणु प्रार्थना करके उपरोक्त नालिक सालिस भारतीय न्याय सहित आईन दफा अनुसार 175 ग मते खुर्दा थाना को पठा जाई मुद्दाला मध्य कुदल कार्य ग्रहण करा जाऊ to send the IIC for investigation, my lord. But the magistrate, my lord, to so much taken cognizance and taken cognizance, my lord. That order I am challenging, my lord. That apart from that, the prima facie is not made out, my lord. He is taken cognizance 296 and 50 lordships.
Yes.
That order I am challenging, my lord. Let them issue notice and then let them appear.
Where is the FIR? Where is the charge sheet?
FIR is not there, my lord. FIR is not a complaint case, my lord.
Where is the complaint?
I have filed my lord, next 13, my lord, page 13.
Statements.
Statement, my lord.
If read the middle part of it.
Yes. The prayer is, my lord. एणु प्रार्थना करू कि उपरोक्त कारण दृष्टि उक्त नालिश दरखास्त को भारतीय न्याय सहित आईन दफा 175 मते खुर्दा आदर्श थाना को
Read the middle. Just see.
My lord.
Middle part of that.
Yes. आम परिवार को खाद्य विषय दे सफा कर दे धमक देउछन्दी, my lord. This is complaint petition, my lord. Apart from that, my lord, in initial statement, my lord, is stated, my lord, my daughter-in-law came to my house at about 4 p.m.
Where is that in initial statement?
I am not given it, the copy, my lord.
Give it.
Para to alerts. Without sending to IIC, my lord, the
main ground should have been C.
Without my suspicion,
no affidavit.
My lord, he has filed affidavit. He has prayed for only to send the IIC investigation. But magistrate so not without without amendment has taken cognizance, my lord. Only simple FIR is lost. Family dispute, lordship, this is the family dispute. Mother-in-law lost the FIR against the daughter-in-law and is Samudi and others my lord.
My lordship, actually mother.
There is nothing. No
It's a family.
initial statement also. Nothing. Please notice to the opposite party.
Without amendment, my lord, the Lord passed order, my lord. How the 156.3 is available, my lord?
Open for the petition, to move application, seeking a general review for the court. Yes. Yes.
61.
The petitioner came before this honorable court for 205. And by that time, the honorable Supreme Court judgment came for making the application. Accordingly, they appeared before the court and furnished the bond under section 88. Now, after furnishing the bond, the petitioners hails from Gunpur, Raigada. So distance is around 450, and they are all are senior citizens, all the three. So we made a petition that 205 be allowed. So because the distance,
another application.
That was rejected, saying that distance is not a factor, this and all that. That's the only ground.
In
this case, I am appealing for the
petitioner.
Last para, my lord. The page 23.
Agreed by the order dated 2/12/2024, whereby the application moved by the petitioners seeking dispensation of service and seeking dispense with their personal attendance in the case has been turned out. Mr. Mahapatra, then counsel for the petitioner, submits that earlier the petitioner moved an application under section 205 CRPC, which was turned out. And you approach this court or straight away you?
No, we approached this honorable court. So by that time,
where is that order? Can you just see?
So that order. So that order, lordship directed in view of the honorable
Because of that
Supreme
judgment,
Apex.
what is that judgment? That judgment, what is
That was.
that judgment? You have that order. You get.
25/24.
We approve this court. And this court, while allowing the application, allowing the CRLMC number 3009 of 2023 on the 48 parts of the observation, directed the petitioner to appear before the court and move fresh application in the line of the judgment for the Honorable Supreme Court in Criminal Appeal number 2608 of 2024. Personnel of Director versus Directorate of Enforcement, Jalandhar. The petitioner appeared before the court below and furnished the bail bond and were enlarged on bail. Subsequent thereto, they moved another application under section 205 CRPC seeking exemption on the ground that they are the resident of Gunpur, which is about 400 kilometers away.
And also senior citizen.
From Bhubaneswar. Apart besides that, the petitioners are senior citizens.
Having some elements.
Therefore, they sought exemption. They sought personal exemption from appearing in the court. The same share application has been turned down by the interim order. Issue notice to opposite party number 2.
I'm appealing. I'm appealing this case.
No, this is PMLA.
Enforcement Director, yes.
Achha.
I am the return counsel.
You just see.
Yes, yes.
Shall I allow it?
No, one day. Because I have to see the complaint petition, what are the allegations.
It's not
all this.
required to.
Those are necessary.
No. See, what I'll say is, as and when required, they'll appear.
Yes.
Yes.
They will appear through.
It will be done by the next statement.
They will appear through video conferencing mode or through the lawyer under moving application 317.
1 week after.
Similar order being passed by.
Department.
This is the similar order.
That will strike a balance.
Similar order has been passed in other case.
It will be fair.
Similar order has been passed.
They are required. They have to appear.
Yes. It is the first date. Have to take this.
Already disposed of similar offenses.
Yes.
Let's see.
Yes, yes.
This is a balance order.
Yes, next date.
At least
Department should know. Department should know at least.
the idea,
My lord.
idea is
Yes.
you make sure that the accused should present in the court and the proceedings should go on. They are on bail.
By the next date, you will also.
I'll pass this order.
Next. By the next date.
Allowed. Agent, when I'll record your objection. Record the objection also. Vehemently. Agent, when he will appear in person, when the court requires, the rest of the time either video conferencing mode or 317.
Language of 305 as and when required. That is also the.
Agent, that's right. Okay. Yes. 62.
When at a question of the criminal proceeding, but I'm challenging the cognizance order dated 28/5/2007, Annex 2, page 13, under section 138 of the NI Act. About a cognizance taken against two persons, one Shamlal Das Mahapatra and against the petitioner. Petitioner is the proprietor of GSN Murti Private Limited, residing Calcutta. And Shamlal Das is the only sole in charge of that farm. And he independent taken all the decision on all work and dated on 25/9/2006, he issued a check of 2 lakhs in favor of the complainant. That check was 30/10/2006, that is check bounce. So their complaint petition file. My humble submission, that is the Shamlal Das the only in charge of that farm, that is admitted fact by the complainant annexure 1 page 10. And he is the only the sole signatory of that check. And the legal notice issued against the name of the Shamlal Das. It is not clear whether the check issued whether officially or personally. In which purpose that check issued, that is also not clear, my lord.
Or the trial, that is the reason the trial.
No, nowhere petitioner, my lord.
That is the reason the trial is conducted.
And that is 18 year proceedings are pending.
2007. Now, you are agreed by what?
Yes.
It is cognizance that is when stop.
Where is the complaint?
Annexure 2 page 13, my lord. Annexure 2 page 13.
2. (2007).
My lord.
I don't know. Where is the proceedings? Part of the proceeding you have filed, part of the proceeding you have not filed.
Thereafter, my lord, that stopped. Till now, no further proceedings there, my lord.
Now, how will I know? Where have you said that?
Lord, sir, call for the record.
No. I can't. Is a 138 case, it is 2007, it is pending.
Would have filed the certificate.
My lord.
You have not filed anything.
Yes, my lord.
Now I will keep on collecting annexure.
I will file them, my lord.
I can't collect annexures for you. You want to substantiate a case, substantiate. It is a 138 matter. 2007, it is pending. Now you have filed a petition, you have to substantiate the case. Why should I quash like this? Rather, I will give a direction to the trial court to expedite the.
My lord.
That's the best way.
Yes, my lord.
Most fair.
Petitioner is one of the accused in the 1CC case number 4 of 2007. He seeks quashing of the entire complaint case initiated by the opposite party number 2 under section 138 on the ground that although the case had been initiated in the year 2007, but the trial is unnecessarily prolonged. The delay procrastination for the trial is not attributable to him. However, he is suffering the trial. And therefore, he seeks indulgence of this court for quashing of the entire proceeding. The documents placed before the court, before this court in the present proceeding. The result of the document placed before this court in the present proceeding. Which I made also the case at the section 130. Hence, I am not inclined to entertain the petition for quashing. However, regarding to the fact that the complaint is pending since 2007 and the mandate under section 130 143 NI Act. The mandate of law under 130 143 NI Act is to conclude the trial within a period of 6 months. 6 months. Therefore, it would be expedient to direct the trial court to do well to see that the trial of the case is concluded as expediently as possible within a period of 6 months. But this observation petition is put up here.
63.
Here 125 application allows ex parte against me and the husband against which I prefer a revision. Revision distance. I may pay a lordship 126 provisional there to file settle the accept judgment. With that liberty, I may be.
Petitioner is agreed by the order. Where is that order? Agreed by the order dated 6/1/2025, passed by additional district and sessions in Padampur in criminal revision petition number 6 of 2024, whereby the ex parte order dated 29/9/2023, passed by TGM Padampur in CMC number 23 of 2020 under section 125 CRPC has been rejected. Mr. General and counsel for the petitioner submits that against the rejection against an order ex parte order under section 125 CRPC, he
126 is
he can very well prefer an application under section
126 that may be
126. Hence, he seeks to withdraw this petition to avail the remedy under right remedy under law. With this liberty, the petition is disposed. Yes.
64.
Here, my lord, the petitioner challenges the criminal proceeding, my lord. Offense under section 420, 468, 471 of IPC, my lord. Allegation is that, my lord, while the petitioner was working as teacher, my lord, at Hadia, an allegation was made that he has produced the fake BEd certificate, my lord. And during investigation by the inquiry by the authority of the school and mass education, my lord, it came to light that the certificate is genuine. Accordingly, the additional secretary school and mass education directed the concerned authority to reinstate him. And
where is that genuine thing?
Annexor. That certificate is, my lord, Annexor 5, page 20, my lord.
Annexor?
Annexor 5, page 20. Last paragraph, your lordship, kindly have a glance. Page 20.
Yes. So as you say,
again, the assistant registrar of the said university,
Ghanshyam Bhoi,
my lord. Last paragraph, the findings of the additional secretary.
last paragraph. Now,
My
the
lord.
discharge is genuine. Yes,
Yes,
sir.
my lord.
Pondicherry, yes.
Pondicherry.
Now,
Yes, that is
since the
genuine.
PO has submitted the information, lost the information. Now, this is the finding. So, I have to take the steps on what is the matter.
Now,
From
it is-
Pondicherry University.
whatever, now it is
But the university-
found to be genuine and
Genuine.
he has been reinstated.
Reinstated.
Genuine means that may not be approved university, all these things.
But you have been reinstated.
Because
But the-
now BO has submitted the.
BO has submitted,
I know,
but the
the-
additional secretary has
The
BEO.
district education officer has filed a complaint saying that his certificate is fraud. Therefore, FIR was registered. It was departmentally inquired, and now they found that certificate is genuine, and he was reinstated.
Reinstated, my lord.
Then where is the criminal case now?
Now he is in also service, my lord.
This letter should have been addressed to the inspector also.
Yes, during investigation.
Not done.
You just forget this,
yes,
that.
I've-
Why to suffer? Why will he suffer? Don't bring technicalities.
Yes, I have
Come to the
take
point.
instruction. What is the matter?
Come to the
Take
point.
instruction.
You said that the certificate is not genuine, terminated him service and initiated criminal proceeding. In the departmentally, you verified it. Now you found it to be correct.
It may not have some approved university on these things.
But the
in that sense,
finding of the,
Why-
this is the
why-
finding of the
why
additional.
somebody will keep on fighting for procedural thing.
Because of these pending cases, my
There
lord,
are-
he is not getting
there
the
are
salary, my
several
lord.
cases are there
Because of
also
these
like-
cases, yes, my lord.
Mr. Mishra, learned counsel for the petitioner submits that the FIR was registered at the instance of DEO of which area?
DO Koraput, my lord.
DEO Koraput, District Education of Koraput, on the allegation that the petitioner has caused the B.Ed certificate.
Paid, my lord.
B.Ed certificate.
FIR lodge on the instance of BO Jaipur, my lord. Block education, block education.
officer.
Block block education. And the meanwhile the department has inquired about the genuineness of the certificate, and by the office order dated 4/7/2023, the Director of Elementary Education Orissa Bhubaneswar has ascertained that the B.Ed certificate which was allegedly false found to be genuine, On the basis of which the petitioner has been reinstated in the job, on the base relying upon the office relying upon the verification relying upon the office letter dated 4/7/2023 of Directorate of Elementary Education Orissa. The petitioner is seeking passing of the entire criminal prosecution initiated against him. Issue notice to opposite party number so written within 2 weeks. Mr. So accept notice, and in the meantime proceeding before so is state. Yes.
Stay further proceed.
Further proceeding. Yes.
65. Here, my lord, I challenge the order of cognizance dated 29/4/2023 in 138 NI Act, my lord.
Yes.
And as well as the dismissal of non-maintainability petition filed by the present petitioner.
Dismissal of what?
Non-maintainability petition.
Okay.
Yes, my lord. Here what happened, my lord? The statutory provisions has been violated, my lord. The statutory provisions mean, my lord, the cause of action, my lord. The cause of action of filing of a 138 NI, the statute provides that occurs to the complainant after expiry of the 15 days from the date of receipt of the legal notice, my lord. After expiry of the 15 days of the legal notice, then the cause of action arose, my lord. Here what happened, my lord? The legal notice was issued on 13/4/23. The same was received by the present petitioner 17/4/23. My lord, within 10 days, my lord, the complaint case was filed, my lord, on 27/4. No, on the 10th day, my lord.
Where is that?
10th day. And my lord, while the complainant violated the statutory provisions, the London magistrate also taken cognizance on 29/4. And just after 2 days, the cognizance was taken, my lord. The all are against the statutory provisions, my lord.
130%.
And my lord, that things are raised before the London magistrate in the non-maintainability petition, that the provisions has been violated.
Date of issuance of notice or date of
Yes, my
receipt
lord.
of notice?
Yes, my lord. The statute clearly provides that cause of action to file complaint occurs to the complainant after expiry of 15 days from the date of receipt of demand notice.
Where are you reading?
Yes, my lord. I am.
Which provision you are reading?
Yes, my lord.
I have a book.
The provision 138 NI Act, that is my lord.
There is some
Reading the provision.
The cause of filing of the complaint. Proviso, my lord. Proviso. Proviso 31, my lord.
Proviso?
Proviso 31 of the Negotiable Instrument Act, my lord. That occurs complainant after expiry of 15 days of the receipt of the demand notice. Here, my lord, on the
Related to
10th.
decisions. Commentary.
Here, my lord, the complaint petition was filed on the 10th day. The petitioner neither get the opportunity to reply the demand notice. That is one violation, my lord. Second violation, my lord, on the 12th day, my lord, the Lord and Master taken cognizance. That is under challenge, my lord. And when the non-maintainability petition was filed, my lord,
Notice challenging the initiation of petition is agreed by the order dated. Where is that order?
my lord, order is at page, my
Order
lord,
dated
cognizance order is at page 13.
2023, passed by learned JMFC Baleswar, whereby cognizance of offence punished under section 138 and has been taken against him, and also agreed by the order dated 20th 28 bar of the year passed by the learned JMFC, whereby the application moved by him questioning the maintainability of the IT 150 case number 405 of 2023 is all turned out. And the counsel for the petitioner submits that the complaint is statutorily barred because it is admitted case on record that the notice under section 138 bracket B for NIS is stated to be issued by the complainant opposite party to the petitioner on 13/4/2023, which is averred by the complainant that the notice was served on the petitioner on 17/4/2023, whereas the complaint has been filed on 27/4/2023, immediately after within 10 days after the receipt of the notice. The statute demands that no cognizance, no complaint should be entertained before 15 days after receipt of
demand notice.
The notice. Since the complaint is filed within 10 days after service of the legal notice, the complaint is bar under law. Issue notice to opposite party. So, in the meantime, petitioner is given liberty to move application before the High Court for seeking adjournment. Yes.
Applying.
Yes.
66.
My lord, in item 66 on behalf of Mr. Santosh Kumar, I'm paying for adjournment for tomorrow.
Santosh Kumar Samantra, adjournment. Huh? Yes.
67.
Page 76 of my brief. The order dated 27/11/2024.
Yes.
My lord, got it. Page 76.
Yes.
Order dated 27/11/2024.
Yes.
Your land, magistrate has taken cognizance of section 302(120)B, 201 and 34 IPC on a complaint petition. Here, in the present case at hand, my lord would find that Mahanga PS case number 133 of 2022 was ended with final report as a mistake of fact. And if your lordship kindly see the page 41, what is the reason why the investigating officer has stated it is a false case?
Because let us come to the protest petition.
Protest petition under Annex 3, my lord.
What are the allegations?
Allegations, lord, if your lordship see the protest petition, as well as 202 inquiry statements, my lord finds some allegations against one Subrat Behra, who has been added here as petitioner number 7. Last sale at best last seen theory as against petition number 7. Except petition number 7, I don't think any allegations so far as the other petition. Here, this is a case, a minor son of the informant committed suicide in the railway track. On the allegations that minor daughter of the petition number 3, there was love affairs between the minor son of the informant and minor daughter of petition number 3. Minor daughter of petition number 3 betrayed him. Out of frustration, he committed suicide. Now commit suicide becomes a case of murder. That you also will find from the charge sheet, a final report submitted by the investigating officer while investigating the case. Soon before death of the deceased, he has talked with 2 friends over telephone and video calling also. That has been seized by the investigating officer. Both the friends insisted him, both the friends also tried to persuade him, but he committed suicide. And after 3 days of the commission of suicide, FIR was lodged. And they voluntarily cremated the dead body, no complaint whatsoever about even the GRPS. They lodged an FIR 3 days after. It was ended with final report.
But the complaint protest petition is very exhaustive one, giving minute detail. Minute detail.
But if a Lord's will kindly say 202 inquiry made by all the evidence, at best as against Subrat, whereas some allegations are there, last in theory. So far as other petitioners are concerned, there is nothing. And interestingly, if you also kindly see the improved
order. You have made everybody petitioner.
Again?
Subrat is also
all the family members of the
Subrat is also petitioner. You should have filed leaving Subrat apart.
Because all the accused have implicated. Some allegations, I consider some allegations.
Some allegation against someone, some allegation against someone and all.
Only allegations against Subrat, some allegations against Subrat. So far as last in theory is concerned. And that apartment, you lordship kindly see that this is a cognizance order on a basis of complaint petition.
Problem is a case of 302 now. Cognizance is taken in 302.
No, it was also 302. It was also 302.
But it is the probate petition is minute detail and just see the initial statements also.
My lord, kindly see. Initial statement and 202 inquiry.
And not only one witness, many witnesses.
10 witnesses. That's why I have examined all witnesses. So except some allegations against Subrat, I don't think any of the petitioners.
Everything has to be, now read over and understand and appreciate 161 statement. Then only I can make out a case, whether case is made out against X, Y, Z or not.
There is no scope.
I issue notice. Let the
magistrate. Some allegations are there.
It is arising out of a protest petition. Let the complainant come. We'll see. Issue notice. Let them come. We'll ask it. Because see, page 50 to page 73. All the we can't read everything and try to find out whether case is made out or not. It's a cognizance stage.
This is a case of 302, not that 506. If right of the accused person,
that's the reason I'm issuing notice. Otherwise, it's not a case for issuance of notice.
I have implemented
because now in a protest petition 302 is so therefore it is he has to face such a serious charges. It has to be looked into. Yes, next.
68. Right, protest. I trained on adjournment application like that. Otherwise, it will proceed.
Yes,
my lord, I beg pardon, my lord. Item 66. The adjourned to 4x after I was held up in another court. So I requested my one.
I don't go reverse way. I go.
I'm sorry.
Again, next.
68, Matrimonial. 68, my lord. The Quashing of cognizance, order dated 21/10/2022. Cognizance taken by the additional district sessions of Hon'Ble against the accused person on the allegation that the offence under section 21A(I) of the NDPS Act. This is what the very allegation, Miller. Please to see the affair on the reliable sources of information
the SI of Monomota police station lost a report that allegation that some villagers of 3 villages there, Rishibam, Guhabam, and Swarnavali villages has cultivated illegally cannabis. This is the only concern. But active persons of the petition and least concerned, my lord, because they do not know they are innocent villagers. And there is no evidence at all. And I have also filed the subject before they are not possible.
What have you filed? Where are the statements? 161 statement, nothing is filed.
Statement, my lord.
The other documents form part of the charge sheet.
My lord. Entire charge sheet I have filed and order of
Not entire charge.
also, but 161 I do not find.
Let's see.
161.
The case has to be seen on the basis of the evidence and all.
NDPS, man.
NDPS, I can't pass like this. NDPS cases are not passed. Yes, who all are the accused persons are Mohan Kuntali, Yes, see. What are the allegations?
They are no way connected, my lord.
There are evidences.
There are evidence there. There are evidence.
Liberty will give it to raise all these objections there, the trial before.
There are direct evidence, sir. You can't pass like. You withdraw it and move an application before trial. Let a counsel for the petitioner seeks to withdraw the present petition to move application before the trial court, raising all the issues as has been raised in the present petition. If such application is moved, the same shall be considered for its merit with this liberty petition is disposed of. Yes. Yes.
69 May. The petitioner placed for the renewal of the passport, my lord. That's we challenge the order dated 1/8/2024, annexure 5. Let's we can say at page 30, my lord. The earlier petition filed the read petition, let's be annexure 3, my lord. Let's see. Also, my lord, annexure 3. Let's we can say annexure 3 at page 22, my lord.
30.
22, my lord. Let's first. Earlier, my lord, the petition also filed.
What should I
lord, observation or judgment of the court.
1 minute, sir. What should I read? You are saying 30.
22, my lord.
Once I go to 30, you bring me to
22. 22, my lord. Let's see.
Please, yes.
The petitioner service in a private company, my lord.
Yes.
The petitioner's wife filed the under section 125 service petition, also filed the FIR, my lord, in 2021. Till date, no charge sheet already filed, my lord. Initiated offense under section 498, 323, 294, 506, and 34 IPC, my lord. Earlier filed the petition, read petition, my lord, page 22, my lord also directed to necessary undertaking the petition to ensure there is no privilege. 15 दिन ପାଇଁ ସେମାନେ ଦେଲେ direction କଲେ 15 दिन ପାଇଁ ସିଏ ଗଲା ବାହାର को passport ନେଇକିରି ତାପରେ then renewal ପାଇଁ apply କଲା renewal apply କଲା ପରେ my lord the reject page 30, my lord. Then charge sheet file any more.
What is page 23?
page 23. Page 23 my lord, then renewal पे apply कला refuse कले तापर से मैं हाई कोर्ट को आसले हाई कोर्ट कहले नहीं तुम लोन कोर्ट बिलो रे तुम फाइलिंग करो कोर्ट बोले पेज 30 रे से रिजेक्ट कले renewal only renewal करिया पे 15 दिन पे मोर any undertaking till date पर्यंत चार्ज शीट भी फाइल है.
The 482 court can't pass an order for renewal
because read petition file 226 रे चकले SDGM court जेम judicial magistrate of the first class court pass करछि order माने read not liable 482 दे maintainable.
No.
Yes my lord.
Can't give a direction for renewal of your passport like this.
Passport authorization.
Let's see, you went to the writ court. Writ court said that you move application. You moved application, which has been turned down.
Then
482, how can I expand my jurisdiction in 482?
Then my lord, 226 already filed, appear the passport union authority already filed the object, counter my lord. Thereafter, Honorable Justice Mishra my lord directed to change the nomenclature change the 482, then 482 filed my lord.
Where is that?
The read petition order my lord. See my lord.
Which read petition?
Se read ହେଇଛି conversion ହେଇଛି CRLMs की.
Where is that? Show me.
ଏଟା ମୋ ପାଖରେ ହଁ ସେ last one.
Orders are passed in read petition only.
The passport authority is also filed objection.
You have included passport authority.
Passport authority already filed the objection my lord.
No, how are you saying that it is converted to CRLMC? To me. Where is that? If the order is passed in read petition.
Conversion खाली कहले.
Where is that? Show me.
Yes, my lord. No.
That's the problem. You are saying something.
Yes. Can take now next one. So
just come to page 23.
23, my lord. Yes. Pendants last 3.1.
On the top you see read petition civil number 10906 of 2024. In that read petition order is passed.
Yes.
Because passport authority was made a respondent.
Yes.
And a 482 court, if anything pertain to the criminal proceeding which is going on, I can exercise the power. You are impleading now regional passport authority.
Because judicial magistrate of
first class.
Because judicial magistrate of first class passed the order.
I generally don't go by the technicality, but there is a problem. I
technically mu jaithili 226 रे फाइल करथली आज्ञा मु फाइल कला पर सेमान भी अपियर करिकरी पासपोर्ट अथॉरिटी यूनियन ऑफ इंडिया तंकर काउंटर फाइल करथिले हियरिंग पे फिक्स हेतिला कि ऑनरेबल कोर्ट हाई कोर्ट मतलब डायरेक्शन कले ना नोमेनक्लेचर चेंज हो जुडिशियल मैजिस्ट्रेट
से कहीं कोन आंदो सेटा कहीं
से ऑर्डर say order
order dated 13 to 2025 in WPC number 21843.
Where is that order? It's not that order is counsel for the petitioner seeks time to place some record and some document to substantiate the case. Please better. Yes, next. 70. If file the document, we'll see.
Yes,
Welcome. Yes.
Challenging the order making compliance order dated 2024. The cognizance taken by the Lord and Judicial Magistrate Maker under section the CTC 376 2 and 294.
Yes, I got it. Yes.
And 506 million. They please to find the FR mailor. FR Jack which 161 ठीक उल्टा कुछ. Please to find them. I am reading my lord permit.
देखिए.
Mailor. If they have already married already. Bhubaneswar Vishnugana Khandiya Mandir.
Yes.
They have already married.
498 376.
What a car marriage is
Notice.
498 376.
376.
Issue notice.
Mail, village.
71.
The entry motor will cancel miscase. Okay.
71. Yes.
The covenants are 15/4/2020
the that the I was submitted the charge sheet under section 341, 342, 294, 323, 376, 376,
Forget about the section.
367, yes, 367.
Forget about the section. What are the allegations?
506, 379, and 34.
Forget about the sections. Sections. How many sections are there? We'll keep on reading. What are the allegations?
Yes, sir. That during pendency of this case, my lord, before the Lord additional session judge Athagar for appearing of the present petition and others, and then could not appear, for which the Lord trial court issue NBW, and virtue of the NBW, the present petitioners arrested, and the informant and the informant, OP number 2, and also the victim of the custody, and while they are in judicial custody, the present petitions are judicial custody, the informant of the victim appear before the trial court and proceeded examination.
Why should I quash it? Just tell me.
Yes, my lord. Already PW1, my lord, kindly see the page, my lord. 29, my lord. 28, file affidavit, that in the affidavit, my lord, that I am in the informant in this case, that the above case already been compromised by the intervenor of the local justice, and as such our good relationship with the member. That view of the compromise, I do not want to proceed this case, my lord. And next page 29, my lord, will PW1, the victim, my lord. He also, I am the informant in this
Notice,
case.
no.
I know the accused person.
Notice, no.
No. These are the evidence recorded in the trial court.
Yes, my lord.
Where is that?
Page 29, my lord.
29.
And sir, 6 series, my lord.
The evidence is recorded, then the trial court will take a call. You will be a good at. How can I exercise?
What happened, my lord? Yes, my lord.
I can't scuttle the trial.
The trial
and the witnesses have not supported the prosecution. Then you will be a good at. Why have you come here?
And what happened, my lord? The trial court after PW1, my lord, already accused statement is already completed, and thereafter on 22/24 for adduced evidence on behalf of the defendant, and according to the defense evidence is closed, and soon after the defense evidence is closed, the land APP file a petition for examination of the charge sheet witness 3, 4, 5, and 11, and the same petition was allowed without giving any opportunity of the hearing for the petitioners, and the petition is allowed, while the illegal without application for judicial amendment. PW1 compromise कला close कले माने defense पे close हला accused statement हला judgment हवा कहता है किंतु in meantime में ये सब illegal
कौन
Lon APP file a petition for the
APP filed the petition not to examine the witnesses. That's good.
No. Examine the witnesses number of 3, 4, 5, and 11. Page 32, my lord, kindly.
30?
32.
32.
There are. My lord, 36, my lord. 36, page 36. Order dated 22/11/24. Two tips are produced along with the warrant. Counsel for the UTP filed a memo standing there. The defense evidence is declared in this case. Hence, evidence from the side of the defendant is closed. At that instance, an APP filed a petition with a prayer to examine CS witness cell number 3, 4, 5, and 11 on the grounds stated there. Copy served with observation that prayer is allowed.
Where is that application? What are the grounds?
Application to
Where is that application? Why is the prosecution is willing to examine 3, 4, 5, and 11? Where is that?
No, copy is not annex.
That ground has to be seen.
Yes.
What was the ground?
So next week, my lord.
Huh?
Next week, my lord, next week, I will file those.
Shall I set aside and direct the trial court to give reasons? Because there is no reason, no opportunity. Copies heard with objection and same day allowed. See, the problem he is not able to convey. The problem is the witnesses have not supported the prosecution.
Yes.
Because they have settled with it. 313 statement was recorded. And after that, the PP moves an application seeking recalling of those witnesses, those who have not supported. And on the same day when the application is moved, the copy received with objection, and the same day the trial court allows.
If the order will be set aside, then the petition stands, the petition again will be considered.
Again, give opportunity and consider what is this?
Yes, yes.
Right. Petitioner is agreed by the order dated, but you are challenging something else in the prayer. You should have challenged this. Just see what you are prayer. You are challenging cognizance order which is taken in 2020. Who will interfere? You should have challenged this order. Unfortunately, you are challenging cognizance order. On that ground, I can dismiss it. In 2020, cognizance is taken, thereafter much has happened. Although the petitioner is assailing the order dated 15/4/2020, passed by the learned SDJ Attogoda, whereby the cognizance of offences punishable under section 341, 342, 294, 323 is taken. But the petitioner at the outset has taken me to the order dated 22/11/2024, passed by the learned additional sessions at Attogoda, and submits that all the witnesses examined by the prosecution has not supported the petitioner, not supported the prosecution, and thereafter a statement of the accused under section 313 was also recorded. At that stage, the learned PP moved an application for recalling the witness number 3, 4, 5, and 11. For examining the charged witnesses number 3, 4, 5, and 11. 11. The copy of the application was served on the petitioner accused. The petitioner accused, counsel for the petitioner accused, accepted the received the copy of the application with objection. The trial court allowed the application of the prosecutor on the same day, by passing a cryptic order, only stating that the prayer made by the prosecutor is allowed. The counsel for the petitioner submits that the petitioner was entitled to the application and entitled to be heard on such a crucial application, which will change the entire scenario of the prosecution case. The submission made by the petitioner seems to be meritorious, and the order dated 22/11/2024 passed by the additional cases said Attogoda, without affording the petitioner accused an opportunity, is devoid of, is not sustainable. Hence, I set aside the order dated 22/11/2024. However, and direct the trial court to deal with the application of the prosecutor to move with a prayer to examine the charge sheet witness number 3, 4, 5, and 11. 11 by giving an opportunity of hearing to the petitioner accused.
If already examined, most
if not examined, because it was fixed on 4/12/2020.
Yes.
With this observation, the petition will be proven.
72, may I please? The petition under 482 for quashing of the affair. The police case number 103 of 2024 of Mohila PS case. My lord, the victim and the accused both are friends and having love and affair. Accordingly, there is some dispute, and for that,
The victim has lodged an affair in 22nd June 2024 in Hall PS in Bangalore.
Yeah.
The affair is typed in page 4 of my petition. Can I press that? Page 4 of the petition. The handwriting, so because I'm typed. And that I informed victim, beg to state that a guy named Omkar Yadav, son of Indra Balia, phone number so and so, physically harassing me since May 2020 and mentally torturing me by using rubbish slangs and languages, verbally abused me and harassing me. He physically forced me for taking an inappropriate relation sexually. When I denied, he started disturbing me by uncontrollably coming to my PG, giving me threats and using slangs.
Ready. You're talking basically.
Accordingly, I am arrested and released on bail on 26th June 2024. And then same set of facts. Now, another affair has been lost in Mahila PS case number 103 at Kotak.
26, when you release your
I released on 26th June, after 4 days. 22nd June, the FIR is lost, and 26th June, I am released on bail.
Yes.
It is on page.
Okay, it's all right. Thereafter, what happened?
Then after, at 10th July, but just after 15 days, 10th July, another FIR being lost on same set of facts. The FIR story is on page 6.
Where is that FIR?
FIR is in annexure 6, page number 95, 2101.
At page 97.
As page 97, it is handwritten. And I typed in page 6 in my petition.
Yes.
May I press? Pursuing my
same
same set of facts because
the same complaint or someone else?
Some
complaint same.
Different complaint.
Different.
This is
story has been written in different words, but the complaint is same.
Complaint same.
Complaint is same, yes.
Complaint same, and I'm released on bail, and I am somewhere in Bangalore.
Let's see what you see. Yes, read it.
Yes. I so pursuing my career in the Hollywood film and modeling industry at present in Odisha as well as in Bangalore. One of my male friend who has known me very well from the same industry since 1 year, named Indra Chaitanya Omkar Yadav, is son of so and so, residents of Kesbera, Niladri, Bihar, Taudiaganj, Dr. Len Kotak, had a good relation with me. Since the day we met, we had close talks and planning to marry each other very soon. But with passage of time, I felt uncomfortable on being close to him and counting physical relationship. Actually, to continue physical relationship with that guy here in Kotak. One day, I was not feeling well. I denied for any physical relation, as a result of which he has started forcing me mentally and physically to have intercourse with me, which made me traumatized. So I started maintaining distance.
This is a continuation of that.
My lord, that, my lord.
Where you have not implemented it?
My lord, one line.
Why have you not implemented it?
I'm not implicated because there's one thing he has.
There is no because. You tell me why have you not?
Only thing.
Why is there very because you have not implemented it?
Because our statement itself is saying that my.
No, I can't cost like this. I can't cost like 354, 376, 3, everything is there. How can I cost like this?
My lord, one line.
No, I will not do it.
He has started.
Land Council for the seeks to leave up this court to include the informant of the victim as opposite party number 2. Let him do so within a week. Issue notice to newly implemented opposite party. Yes.
Hon'Ble.
Yes.
73.
Challenging the quashing of criminal proceeding, lordship. Here in this case of dispute between both the parties due to civil dispute, and the petitioners filing the CS case number under Annex 2. Thereafter, the opposite parties receiving the notice, thereafter to file a complaint case for the Lawrence Tide court below under Annex 1, let's say. And the 161 statement of informant as well as the father-in-law of the informant.
What is civil about it? You scolded, you kicked him in the belly of the complainant's father, and on all these things are civil.
Yes, Lordship.
This behavior is all civil.
Yes, sir. Can you see
civil behavior?
Can you see the page 39?
Come to the page 13, complaint.
13.
Once you say civil, you have to see the
Page 13, Lordship. Yes, Lordship. Page 13. After the date of occurrence, 4 months
into the house of the complainant and abusing in the filthy language, assaulted the complainant and her grandmother-in-law, for which they succumbed to injury. So they tried to outrage the modesty of the complaint and did the heinous and shameless thing with the complainant, which cannot be.
Let the date of occurrence 3/4/24, and the informant lodged an FIR, the complaint case filed 27/8 after 4 months of the date of occurrence.
But
and thereafter, the Lordship kindly see the page 39. As per the
household articles are stolen.
As per the allegation of the informant,
gold necklace of 2 lakh rupees is snatched.
That is not
played away from the.
That is not made out against the particular. Kindly see the page 39. Father-in-law of the informant.
39.
Yes, Lordship. Yes. She goes in the Sikh dinso tam to nei nari taku chutti moramori karina.
What about the other evidence? Let's see the other statement.
Other statement ताको घर पाकर पड़ोसी father-in-law तो ताको घर पर
Can I appreciate the statement of 161? Few witnesses are saying that. Few witnesses are not saying. Contradiction I can't find in 161 and quash the complaint.
Yes, Lord.
Can't do that.
But not made out against the petitioner the allegation the 379 and 354.
You move application. Withdraw and move application.
Yeah, notice maybe.
The petitioner is seeking quashing of for the FIR number so or the mistake that the instance of this party number 2 for a late commission of offense and the statement of the witnesses under section 161 CRPC was recorded, which has been placed on record as an Excel 3. The result of the statement of the witnesses and the complaint from make out the case against the petitioner, and then inclined to entertain this petition in this stage. However, liberties and technical petitioner.
He may pay also. One thing.
Move appropriate application to the trial court at appropriate stage. Appropriate stage.
After framing charge sheet.
Yes, that's what it is. Yes.
24.
May I please, your Lordship? Here I paid filed this 482 application for quashing of the entire proceeding. My Lordship, see, on 1st June 2022, the District Child Protection Officer Raigada, he lodged an FO before the IIC Raigada, alleging that the baby who was admitted in a nursing home after his death, the body was disposed of without prior intimation of the parent. No care was taken during his treatment at a nursing home. What happened, my lord? On 17 March 2022, a tribal lady, namely Parvati Heplika, while she was taking for hospital, on the way she gave birth a child. Due to delivery complications, she died at the spot. Then the husband and other relatives and the ANM Asa Didi of that area, they took to present petitioner's hospital for treatment because it's child care unit in the Raigada town. They admitted. Then Lordship, after 18 days, Nobody didn't turn off. They didn't care about the child. We took the utmost care of the child treatment, but during treatment, he expired.
The child.
Child expired. Even if after expiry, we intimated them to take back the dead body. They didn't turn off. Lordship may see one statement. Now, charge sheet has been filed and cognizance has taken. My lord, the ANM, my lord, page 49. Jamuna Mandangi. May I read, my lord? Jamuna Mandangi, as page 49. ମୁଁ ଯମୁନା ମଣ୍ଡାଙ୍ଗୀ ଆଜି ଆପଣଙ୍କ ଦେବା ମୋର ମୌଖିକ ବୟାନ ଏହିକି ଯେ ମୁଁ ଶେଷକାଲ ଥାନା ଅନ୍ତର୍ଗତ କାରୁବାଇ ଗ୍ରାମର ଆଶାକର୍ମୀ ଭାବେ କାର୍ଯ୍ୟରତ। ଆମ ଗ୍ରାମର ରାଇସିଙ୍ଗା ମେଲକାର ସ୍ତ୍ରୀ ପାର୍ବତୀ ହେପ୍ରିକା ଗୋଟେ ଶିଶୁ ପୁତ୍ରକୁ ଆମ ଗ୍ରାମ ପାଖର ଥିବା ମେଣ୍ଡପାକା ପାହାଡ ନିକଟରେ ଏକ କୁଡିଆରେ ଗତ 17/3/2023 ଜନ୍ମ କରିଥିଲା। ଜନ୍ମ କଲା ପରେ ତାର ଫୁଲ ପଡିନଥିଲା, ଦ ପ୍ଲାସେଣ୍ଟା ମାଲଟ ପଡିନଥିଲା ଏବଂ ସେ ମରି ଯାଇଥିଲା। ସେ ମରିଗଲା ପରେ ଗ୍ରାମର ଲୋକମାନେ ସେହି ଛୁଆକୁ ନେଇ ରାୟଗଡର ମେଡିକାଲରେ ଆଡମିସନ କରିବା ପାଇଁ ନିଷ୍ପତ୍ତି ନେଇଥିଲେ। ତେଣୁ ମୁଁ ସେଇ ଛୁଆର ବାପା ଓ ତାର ଆତା ଅଜା ହବ ଆଜ୍ଞା କଣ ଆତା ଏବଂ ଗ୍ରାମର ୱାର୍ଡ ମେମ୍ବର ମିଶି
Ata means
ପିୟୁସି ଆମ ଗ୍ରାମର ୱାର୍ଡ ମେମ୍ବର ମିଶି 18/3/2022 ଗୋଟେ ଅଟୋରେ ରାଇସିଙ୍ଗା ମେଲକାର ପୁଅକୁ ରାୟଗଡା ନେଇଥିଲୁ। ସେଠାରେ ଆମେ ଜାଣିବାକୁ ପାଇଲୁ ଯେ ରାୟଗଡା ସ୍ଥିତ ନବଜୀବନ ନର୍ସିଂ ହୋମର ଓ ରିସର୍ଚ୍ଚ ସେଣ୍ଟରରେ ଗୋଟେ ଛୋଟ ଛୁଆ ମାନଙ୍କୁ କମ ପଇସାରେ ଭଲ ଚିକିତ୍ସା କରାଯାଉଅଛି। ଏହାପରେ ଆମେ ସମସ୍ତେ ମିଶି ସେଠାରେ ସେଇ ଶିଶୁ ପୁତ୍ରକୁ ଆଡମିସନ କରେଇଥିଲୁ ଓ ସମସ୍ତେ ପଳେଇ ଆସିଲୁ। Nobody was there for no attendant was there. ଏହାପରେ କିଛି ଦିନ ପରେ 26 ଦିନ 2023 ମୁଁ ରାଇସିଙ୍ଗା ମେଲକା ଗ୍ରାମ 3 ଲୋକ ମିଶି ନବଜୀବନ ନର୍ସିଂ ହୋମ ଓ ରିସର୍ଚ୍ଚ ସେଣ୍ଟରକୁ ଯାଇଥିଲୁ। ସେଠାରେ ନର୍ସିଂ ହୋମର ମ୍ୟାନେଜର ଆମକୁ କହିଲେ ଯେ ଶିଶୁ ପୁତ୍ରର ଅବସ୍ଥା ଭଲ ନାହିଁ, ତାକୁ ଅନ୍ୟ ବଡ ଡାକ୍ତରଙ୍କୁ ନେଇ ଚିକିତ୍ସା କରାଅ ବୋଲି। କିନ୍ତୁ ରାଇସିଙ୍ଗା ଓ ଗ୍ରାମର ଲୋକମାନେ ମିଶି ତାଙ୍କ ପାଖରେ ଚିକିତ୍ସା କରିବା ପାଇଁ ସେତେ ଟଙ୍କା ନାହିଁ ବୋଲି କହିଲେ ଓ ଶିଶୁ ପୁତ୍ର ସେହି ନର୍ସିଂ ହୋମର ଚିକିତ୍ସା କରିବା ପାଇଁ କହିଲେ। ତେଣୁ ଆମେ ସବୁ ଉକ୍ତ ନର୍ସିଂ ହୋମର ରାଇସିଙ୍ଗା ଶିଶୁ ପୁତ୍ର ଚିକିତ୍ସା ହେଲେ ଆମର କୌଣସି ଅସୁବିଧା ନାହିଁ ବୋଲି ଲେଖିକରି ଦେଲୁ ଓ ଗ୍ରାମକୁ ପଳେଇ ଆସିଲୁ। ପରେ 4/4/2022 ଉକ୍ତ ନର୍ସିଂ ହୋମର ମ୍ୟାନେଜର ଫୋନ କରି ସେ ଶିଶୁ ପୁତ୍ର ଚିକିତ୍ସାଧୀନ ଅବସ୍ଥାରେ ମରିଯାଇଥିବାର ଖବର ଦେଲେ ଏବଂ ତାର ଶବକୁ ନେଇଯିବାକୁ କହିଲେ। କିନ୍ତୁ 2 ଦିନ ଧରି ରାଇସିଙ୍ଗା ମେଲକା କିମ୍ବା ତା ଘର ଲୋକ କେହି ଶିଶୁ ପୁତ୍ରକୁ ନେବା ପାଇଁ ନ ଯିବାରୁ ସେଇ ନର୍ସିଂ ହୋମ ବାଲା ତାଙ୍କ ଶବକୁ ପୋତି ଦେଇଥିଲେ।
Whose statement is this?
ମାନେ she is the ଆଶାକର୍ମୀ who had given admission of that child to the hospital along with parents.
Kindly glance the statement.
Not yet completed. Thereafter, my lord, I faced the inquiry. The inquiry is initiated by the CDMO Rayagada. I filed my show cause. Before completion of inquiry, this FIR has been lodged.
So then that judgment comes in your favor.
No, my lord. Inquiry
There is a judgment before registration of FIR, the inquiry report has to be there before police. That's the Supreme Court judgment.
Yes. That has not been dealt and FIR and cognizance has been
Have you
taken.
seen that judgment?
No, I have not seen that.
That judgment says against a doctor, if medical negligence FIR is registered, first inquiry report has to be placed before police, thereafter the FIR.
Lordship, for a moment, Lordship, see the annexer 5, annexer 4, page 84.
Yes.
A committee was constituted. I was called.
When the FIR was registered?
1st June 2022.
2022. Okay.
Lordship, page 85. There is an intimation memo. 3rd June, I was intimated to appear before the committee. Page 84. 3/6. Then, my lord,
what is the page?
Annexer 5, page 86.
The
notice was issued by the
committee report.
After submission of report on 3rd June, then 4th June, immediately very next day, I was intimated to file my show cause.
Final report you show me.
No, nothing, my lord. Final report has not submitted. Prior to that, this Lordship may say annexer 6.
ACN when you have given ACN when you got?
My lord, I got intimation 4/6/2022.
4/6/2022.
Then I filed my show cause reply, my lord, annexer 6. That is on 6/6.
Okay.
Then a 1st July was prior to 5 days.
So registered on 1/6/2022. Allegation of the personal.
Attention also.
The petitioner petitioner is seeking quashing of the entire proceeding primarily on two grounds. Firstly, the as per the judgment of the Supreme Court reported in before registration of FIR in a medical negligence case, the report of the competent authority ought to have been placed before the police. However, in the present case, FIR is registered on 1/6/2022. So-called notice has been issued to the petitioner by the
By
SDM.
6/6/2022.
Who has issued? SDM.
CDMO, Raigada.
CDMO, Raigada, on 6/4/2022.
6/6, man.
Sorry, 6/6/2022. The petitioner had replied to the so-called notice on 6/6/2022. The report is still awaited.
That is not
Before
correct.
the-
Also.
Huh?
Charge sheet has clearly mentioned that the explanation suffered from the accused petitioner, the explanation is not satisfactory. Also. That is
The police has no business to do that.
That is
The report has to come from the
committee also. That is what charge sheet has clearly mentioned. That.
The report of the CDMO is still awaited. Mr. Das, further taking me to the statement of one Jamuna Mondagini, the ANM,
Asha Karmi.
Bracket Asha Karmi, who had taken the child to the hospital and got
Only Asha Karmi, Lord Sam say.
Asha Karmi, the ANM. Taken the child to the hospital and got the child admitted in the hospital. For the statement for the said witness under section 161 CRPC reveals that although the child was admitted in the hospital, but there was no family attendant. Family attendant remains in the hospital for about how many days?
18 days.
For 18 days. Subsequently, the child also died, and
Eventually born.
Eventually, the child died. Even after intimation of death of the child, none of the family member turned. Issue notice to opposite party. Issue notice to the state and accept notice. File a counter. This is a case where
Yes, Lord. So I filed, but I brought to kind attention also two things also. Charge sheet has been filed on 1/6/2024 also. My learned seniors filed the annexed.
Anyway, he's let it say.
Charge sheet has been filed also that thereafter lordship 1/6/2024 charge sheet has been filed. The explanation the reply was filed by 6/6/2022 also. That the reply is already taken care of by the committee, and that the report is that the explanation is not satisfactory. From the
report has already.
Charge is clearly mentioned also.
Where is the report?
But report.
That is why I am issuing notice. That is why I am issuing. Check it up. If the report is already there,
yes,
then he has to face it. Issue notice.
Already IA there is.
My application. Yes.
Obliged.
75.
Next. I prefer adjournment to next.
Adjournment.
76.
Question of paper. The petitioner being a lady was working as a assistant teacher of a school, and the verification after verification that the certificate is
by producing fake certificate is engaged in a teacher, and DO has lost complaint. That is the announced for passment of that proceeding.
You got some any report that your certificate is genuine? Just now I issue notice and say if the certificate is genuine, if the departmental proceeding
my lord,
has come, then I'll
my lord, the ladies procure certificate from the institute. That regarding that the investigation is nothing. Now the lady lost his job and lost his social life and his marital life. After engagement, he married to a person and he lost his social life. Kintu the police is behind him for arrest. behind her for arrest. Now he lost his job. The regarding the inquiry,
these are the obvious consequences, but that can't be a ground for quashing. Consequences are there. What to do?
My lord,
Have you yourself verified? Got some document that your certificate is genuine?
Certificate is procured from the institute to you where
Some RTI information, something.
No, the call for a report from the investigation agency regarding.
The problem is you don't file anything, and except FIR, you have not filed anything. Quash it. How can I quash it like this? You have to make out a case. Can't be quashed like this. You show me any document where I can help you out. Except FIR, you have not filed a single document.
इग्नोर से माने बीड सर्टिफिकेट आनले से बीड सर्टिफिकेट टू ए डीओ आफ्टर चाकरी कला पर से वेरिफिकेशन मांगला को से नंबर वेरी कला and clearly made out there is an 420 and 468% made out on the face of the record.
Yes.
And if that is certificate is genuine, then this secret tha that is genuine one. Now he is not no more in service.
ताको सर्टिफिकेट ताको चाकरी बाहर को बेफर करछि
एक सर्टिफिकेट ले बाहर करिवे
हां बाहर को पर ता पर देयर आफ्टर डीओ लॉज्ड एफआईआर.
Obviously.
For recovery of public money misappropriation is not eligible to that post.
My lord,
what is your ground for quashing?
My lord, that certificate is we obtain the certificate from the institute where Kotobanchar sabu BD city so
कहले हबोनी आपन डॉक्यूमेंट देबा पड़ो.
Now the proceeding miscase system I will submit
what kind of submission you are making? I'm intending to dismiss it. Think to save the petition first. Forget about the stay. Save your petition. There is nothing except FIR. You have not filed anything. It's rightly the FIR is registered. Investigation is going on.
My
that part I have no interest in, but my lord.
What is the stage of investigation?
My lord, investigation is
going on. You go and tell all this. The petitioner to withdraw the present petition to apprise all the facts to the investigating officer. If the investigating officer is at it is open for the investigation officer to take into consideration take into consideration the document and the statement of accused to account while filing his report under section 173 report public filing form under section 173 CRPC. With this observation, the petition is made. Yes, next one.
let's see protected.
I pass the order, sir. Yes, next.
77. My lord, the petitioner challenging the order under Annexure 5, that is one where the petitioner's petition for recall of the witness has been rejected. My lord, after examination of the witnesses, my lord, the dispute has been compromised between the petitioner and the victim, my lord. Accordingly, they have filed the joint petition for compromise petition before the court below and a amicable settlement of the agreement, Annexure 3. And thereafter, the petitioner filed a petition for a recall of the witness due to compromise of the dispute.
Where is their evidence?
It's not annexed.
Evidence, have you placed the evidence on record?
The relevant page, my lord. The order, that is page 27, my lord. Page 27. 26, my lord.
Okay.
The record is put out today for consideration of petition. Had a petition, both the loan counsel accused submitted that victim married another person and is spending happy conjugal life, and accused also married another lady and he is spending conjugal life with his family. At this stage, both informant and victim along with the accused agreed that they do not want to proceed this case any further. The informant and victim absolutely no objection if the accused may be acquitted on the strength of this petition with the submission loan counsel for the accused prayed for to allow the petition. Tapre next year say the no order
The 311 CRPC filed by the
The
law.
back end of the trial.
Yes, Your Lordship. Out of 27 charged witnesses, 18 have already been examined until November 2024. Your Lordship. Sorry.
Due to
Where are their evidence? Let us
But
understand.
evidence not filed. Only
At least evidence filed, the witnesses to, witnesses you want to, recall, at least their evidence should be filed.
And that 3 witnesses already been examined 2015. Your Lordship. That is clearly mentioned in trial court.
evidence is with me.
Even if you want to help, you can't help
Yes, yes,
because the
that's-
kind of petitions are being filed. That's the whole difficulty.
My lord,
Land count for the petitioner seeks an adjournment to place on record the additional document to substantiate the case. Let him do so within a week. Please the matter after 2 weeks. Right. File relevant documents you file, then I can help you. I can't help you like this. Yes.
78.
Main documents are not filed.
So challenging the registration of the delivery petitions not for further cross-examination, my lord. Here, my limited appraisal, my lord, let them direction to victim to create a cross-examination, my lord. Here, he played for 3 petitions, victim and father and mother. But my limited appraisal only left direction to the cross-examination of the victim, my lord. PW2.
What are the offenses?
Offense, my lord. 363, 366, 372, and 6 POCSO Act, my lord. There are 31, my lord. Also 3. And I will also given petition. What question to prepare, I have given, my lord.
PW1 is the victim.
PW2 is, my lord.
Who is victim? Your Lordship. That is page 19.
PW2 is
the victim.
Victim.
mother.
PW2 is victim. 3 is mother.
PW3 is mother.
Yes.
Yes, Your Lordship.
PW4 is father.
Yes.
Where are their statement have you filed?
Page 19, Your Lordship.
19?
PW2 rows statement available in page 19, Your Lordship.
19, okay. Yes.
Starts from page 19.
Cross-examined extensively. When was cross-examined?
What question to be put also I will given, my lord. There are 29 words, page 29 verses. My petition.
Let 3 and 4 allowed.
My
3 and 4. Girl child will not be recalled. 3 and 4, one opportunity.
subject to payment of cost.
Subject to payment of cost. Okay. Right. Petition is agreed by the order dated 5/2/2025 passed by the ad hoc additional sessions judge FTSC Kyonger in special case number 105/93 of 2022-2020, whereby the application of the petitioner under section 311 CRPC seeking the recall of the witnesses, namely PW2, 3, and 4 has been turned down. The PW2 is the victim in the present case, whereas PW3 and 4 are the parents of PW2 victim. The witnesses have been examined long back in 2023 on 12/12/2020 and 12/12/2020. 2022, and they were subjected to extensive cross-examination. The learned counsel for the petitioner, what is the reasoning of rejection?
Well, could you see, my lord,
Trial court rejected the application
I said 29,
of
I said
the
29 page, my
petitioner, inter alia observing agent, page 33, para last paragraph, peruse the proposed questions and so on, so on, so. The trial court has evaluated the relevancy of the questions proposed to be put to the witnesses and formed an opinion that the questions sought to be put to the witnesses are not relevant, and part of the questions have already been put to the witnesses. Petitioner is facing charges of offenses punishable under section, both the sections. Tell me the sections.
Yes, Your Lordship.
Section so and so. the petitioner has an indefeasible right to lead the evidence lead the defense evidence repeatedly, as well as he has the right to cross-examine the witnesses. Since the offences alleged against the petitioners are serious, the right of the petitioner to cross-examine the witnesses or to lead defense evidence cannot be curtailed. Hence, I am for the considered view that the petitioner should get adequate opportunity to cross-examine the witnesses. Having said that, insofar as the recalling of the petition of PW2 is concerned, the same cannot be allowed in view of the bar containing under section 33(5) of POCSO Act. Hence, the prayer vis-a-vis PW2 is concerned, it is rejected. However, insofar as PW3 and 4 are concerned, the application under section 311 CRPC moved by the petitioner is allowed, and the trial court is directed to fix a particular date and afford a singular opportunity to the petitioner to cross-examine those witnesses. It is made clear that the petitioner shall not seek adjournment in any on any dates whatsoever on the date to be fixed by the trial court. The petitioner is also liable to pay 5,000 each, 5,000 each to the two witnesses to produce the date to be fixed by the trial court. With this observation, the petition is disposed. Yes.
But more questions are there, right? So that is enough.
You are facing such a this is the this should have been disallowed. Pay 5,000. Nothing.
That's why
2,500, 2,500 kotti. Four people are.
Offense is available paragraph 1 in notes. 363, offense also 363, 366, 376, 2N and 6 post paragraph 1 of the.
Yes. Yes.
79.
My lords, I'm in the virtual mode, lordships.
Yes.
Lordships, I have sought the quashing of the charge sheet against the housewife, who happens to be the wife of the accused person in the disproportionate asset case. And pursuant to Lordship's judgment in Swarnalata, I have filed this thing, though it is quite late down the years. The FIR is of 2011, the charge sheet of 2014. I was not named in the FIR, Lordships. Subsequently, they have roped me in as accused number 2, and they have charge sheeted me, Lordships. And the allegation is that there is some 3 some lakhs deposit in my name, and I had rental income from a house which I was sold in 2007, though the search was conducted in 2011, Lordships. This is the short crux of the matter, Lordships, and my lords may consider issuing notice so that I will be able to take Lordships through the.
What are the allegations against you?
There's nothing, my lords.
Are you putting forth defense to justify the?
My lords, I had a rental income. My lords, I had a rental income which is admitted in their FIR and partly in their charge sheet as well.
Let us see these.
My lords, then kindly, my lords may come to
the charge sheet.
I may be pardon, my lord, Mr. On behalf of Mr. Maharana, who was only felt uneasy, left for home just 15 minutes before. So your lordship may fix to any other date, so he can get the complete charge sheet. He has not got the complete charge sheet.
Minutes, I have the charge sheet. Minutes is also annexed.
I'll put it on Friday, Mr. Samantrai, because Mr. Maharana is not well. Friday.
Minutes is a simple lordship's matter. It requires a consideration because it has to.
Personal account, because he is not well. He was here, right here.
No
Yes.
problem. No problem. No problem. No problem.
My lord, 83 item also.
83. Friday कर दिया Friday.
First time came.
महाराणा को जितनी मैटर थी Friday कर.
Grateful lordship. Deeply obliged.
Did you know? But he was here right now. He was not well. 83 na. 83. I'll put it on Friday. Both Maharana.
I have not filed the reproduction charge sheet.
I'll see, look into that. Better you file it. So that we need not adjourn on that day.
Because that which have been actually action taken.
Whatever you file it, I'll see on Friday.
That has not been investigated.
Friday I'll see. Okay.
Obliged, my lords.
80.
I may please your lordships. My lords, here is a case, my lords. The wife has lost a criminal case. That's 144 of the BNSSS after 10 years, after 15 years of the divorce. Your lordship may kindly have a glance to the divorce order, my lords. Lordship, page 43, the order judgment of the passed by the competent court, my lords.
Yes.
The suit as filed, page 43, my lords.
43.
43, yes, my lords.
Okay.
The suit as filed by the petitioner is allowed on contest against the respondent, but in the circumstances without any cost. The marriage of the petitioner with the respondent is hereby dissolved by a decree of divorce, subject to payment of permanent alimony of rupees 2,50,000.
2010. 9/4/2010. 9/4/2010.
Yes, minutes, yes, it was there. Then after minutes, she went on appeal. Let's see with the, let's make have a glance. In the appeal, she lost the appeal. Then she preferred the second appeal before the Honorable Court. While that is pending without not been admitted till yet. In the year 2011, it is being pending. So I have filed the documents. And that in the meantime, what has happened? She has filed this criminal proceeding, suppressing all these things. Filed
Where is that criminal?
Yes, that is page, that's annexure 7 minutes. And page matters 77.
24.
Yes. 24. Yes. That is 11. November.
The instance of the opposite party number 2. Have you pleaded or not?
Yes, no. So this is the sole opposite party.
Opposite party.
Yes.
The complaint that is being CRP number 248 up to 2024 has been registered. The Acharya accounts for the petitioner has submits that 2007
9/4/2010.
9/4/2010 the
decree of divorce.
Degree of divorce between the petitioner and the opposite party has been granted by the Court of Family Judge.
Civil Judge, Senior Division, Baripada.
Senior Division, Baripada on contest. The proceeding arising, the Mata case filed by the petitioner has also been dismissed.
RFA filed by the respondent.
And the Mata is pending.
Yes, no, the second appeal is pending.
Second appeal.
At her behest.
Second appeal is pending since 2011.
11.
While the matter stood thus, the opposite party on
that is on matters 25/11/2024.
November 2024 filed the present criminal complaint against the petitioner, suppressing the fact that the marriage between the petitioner and opposite party has already been dissolved. Issue notice to opposite party is so and so. In the meantime, proceeding before so and so. Proceeding before which court?
The Judge Family Court, Baripada.
Judge Family Court.
Baripada.
Baripada.
In CRP number 248.
284 of 2020. Mistake. Yes.
Deep problem.
81.
This is a proceeding under section 138 in Act, in which the complainant was examined on 22/12/2017.
Yeah.
And since then, he has not been able to produce any evidence, and neither he closes the evidence nor he adduces any further evidence. And it is lingering since then. Page 16, the order sheet I have annexed.
Yes.
And it is unnecessarily lingering, and it is a pressure on the accused. I am the accused in that case.
When the evidence was recorded?
Evidence was recorded on 22nd December 2017. During last 8 years, he has not been able to adduce any further.
I'll give a direction. petitioner is the at the instance of opposite party number 2. So opposite party number 2. 1cc case number 300 of 2017 has been initiated by the opposite party. No, the instance of opposite party number 2 complaint the 1cc case number 300 from 2 under section 138 has been against the petitioner. Then the counsel for the petitioner submits that on what is the date you said? 12/12? Last evidence?
Last evidence on 22nd December 2017.
Submit that on 20, relying upon the proceedings which placed before this court, again 2. Then counsel for the petitioner submits that on 22nd September 2017, the complainant recorded his statement. Thereafter, no step has been taken by the complainant to conclude the trial and trial. The trial is procrastinating at the instance of the complainant and the petitioner is being harassed. Hence, he seeks indulgence of this court for passing up to the criminal prosecution. I have perused the proceeding placed before me, and the complainant indeed has been seeking adjournment before the trial court repeatedly, as a result of which the trial of the complaint case is delayed. Be that as it may, the under section 143 of NIS, the statute commands that the complaint of present nature should be concluded within a period of 6 months. Since the delay is attributable to the complainant, I would it would be expedient that the trial court is directed to conclude the trial, do well to see that the trial is concluded as expeditiously as possible within a period of 6 months. I feel it not necessary to issue notice to the complainant in the present petition because the entire proceeding, a certified copy of entire proceeding before the court below has been placed in this petition as an exception to perusal of the same makes it clear that it is the complainant who is causing unnecessary delay confusion of the trial of any license case number 4. Yes. With this observation, yes, next.
82.
Yeah, please, Lord. That's the very registration of the FIR is a solemn act of the police, as because the same relates to the personal liberty of the citizen. Here in this case, my humble submission, Lordship, if the FIR has been registered under section 109 of
341, 307, 34, and 25, 1 AFP and 21 of Arms Act.
Yes, 109 is there.
109 is the time 307. I wish to for you.
Okay. Thanks, my friend. And plus my humble submission, the way the FIR has been drafted, and it can impress any prudent person that can cause a very wrong impression. Because I am reading the FIR. The way it has been
What do you want? An investigation is going on. Why have you come here?
No, plus I have come here because my liberty has been is being curtailed because it is sessions tribal offense. 109 attempt to murder, but the injury is only on the elbow and there is a grievous only on the elbow.
Investigated. How do you know?
Pardon?
Let it be investigated now.
Grievous on the elbow. An allegation is that with many persons, 10 to 12 persons came with swords and assaulted me. I mean, assaulted the victim for which he became bloodshed. And when we lie down, they thought that yes, the person is dead, and they left the place. The way it has been drafted, plus the injury is only on the elbow, and it's just injury grievous. Little fracture is there. No, nothing. No sword has been recovered. No, any other weapons have been recovered.
Nothing I need to.
Investigation is going on, FIR is registered, you know everything.
Plus, I know the injury
And
report.
everything. This
Plus,
is-
I know the injury report only.
Huh?
I know the injury report. That's the reason why I have made a submission.
Let it be concluded. Why should I interfere at this stage?
No, because plus the very registration of why it will be registered as 109 instead of 180.
If there is a cognizance offense is made out, it is registered, it has to be investigated. As simple as that.
Plus, at the stage of filing the FIR when the registered, that is also the.
Let the charge sheet be filed.
Plus, your husband
Sections will be diluted after.
By the time my liberty will cut 10 plus. Because I will not get the benefit.
What? Why liberty is cut?
Because suppose I am surrendering for the land magistrate. Suppose plus it will be rejected because there is
surrender. Need not surrender. Now see at the nascent stage of investigation, how do you expect that 482 court will interfere and pass the entire
your lordship is very correct on that point.
And you in the beginning you said the drafting is very well.
Yes, in the beginning,
FIR is very fully drafted.
Yes, tactfully drafted. That is most tactfully drafted. That can impress any prudent person in a bad way. That is my humble people.
That has influenced me too.
Yes, anybody. And your lordship is externally.
See the allegations.
Yes.
And don't doubt my prudency.
Malas, I have already submitted that my lord is extraordinarily prudent.
Got influence.
I am telling you about prudent person. My lord is extraordinarily prudent.
So therefore, it is bound to influence you as really.
Your lordship can see.
No, Mr. Kotke, leave it here. What else you need, you tell me.
Pardon?
I will not quash it. What else you need, you tell me. Come to the point.
Plus, I will not
come to the point. You know that I will not quash. Come to the point.
If the parcel
now you are protected or not?
No, I have not been protected.
You in that direction you think have you?
No, let me very.
Huh?
Yes.
That's the problem. Show me.
There may be millions. That I have stated. Plus, out of 5 persons,
you have already burned your finger.
No, I have. Plus, my second.
You have already burned your fingers. I can't help you.
My second anticipated bill application is maintainable if lordship will interfere in this case.
I'll issue notice.
Yes.
Let him. He's exploring possibility. I'm not saying anything. Simple. See, what he says is his first anticipated bail is rejected, and he is apparently going to be arrested. If I issue notice, he may maintain an application under 438 once again, saying that the 482 court has issued
lordship. Yes.
That way, except that I will not do anything.
That is my requirement.
Okay. I simply
even I'm not praying for any course. No course back.
I'm nothing. I can't pass the. I can't pass. Yes. I'll simply issue notice so that at least you can maintain your 438 second 438. Okay. Change circumstances. Yes, go.
Great for you.
That is the only thing. That straight away you tell me that I'll do it.
Yes, I'm grateful to Lords.
See, what I'll do is the bail jump and matters I'll take it up, and the rest of the matter will be included in tomorrow's list. The rest of the matter will be included in tomorrow's list. Yes. Tomorrow. All the matters will be listed tomorrow again. Supplementary.
Item number 84. Problem is that the in-law family and the victim all are
84. Okay, 84. All the matters tomorrow I'll take. All the matters will be taken up. Withdraw. 95 withdraw.
Pardon, my lord. 96 item. After
100 for.
I will take it up tomorrow. Why do you worry? You want an adjournment? Longer adjournment. 92 adjournment. 92? 96. Adjournment request. Okay?
Pardon, my lord.
84 I'm taking it up.
My lord, item number 102, my lord, is same with the item number CRL number 216, my lord. Disposed upon 17th February, my lord.
Yes, what do you want, Mr. Patel? Yes.
My lord,
this is Praise appeal clears conviction.
Mr. Das, wait, please wait. See what it says. Yes.
This matter? Yes, my lord.
Vigilance matter.
Yes, my lord.
two petitioners are here. Another petitioner has already filed 216 of 25. Your lordship was admitted on 17-2.
Yes, my lord.
102 admit for the admit the
216 of 25.
216 of 25.
Yes.
Of 25. Okay. Okay.
This matter will be tagged with that matter.
Yes, I understood it. Done it. I have done it.
Two petitioners are here.
102 allowed. Yes.
Grateful, my lord.
My lord, 10.
Bail jam matter, I'll take it up. Please wait. And rest of the matter will be taken up tomorrow. Because I'll include this in the supplementary list. Okay. And 84, I'll take it up because parties are there. And bail jam matters, I'll take it up. Okay.
Directed to file the written note of argument within 3 weeks. There, I'll file it.
Yeah.
My lord, I will pardon. Item number 99 and 100.
No, Thursday, Friday. What is the no? On request. On request. Yes. 84.
492.
84.
Let's see. Item answer.
Yes. 84.
Yes.
498.
Yes, your lordship.
498. Yes.
In this case, I am appearing for opposite party number 2, wife.
Give me the evidence.
492,
She has already remarried to remarried.
Remarried. Remarried means they married somewhere else. They married somewhere else or what?
Some other.
Divorce is granted, huh?
Divorce is pending. 13B petition is pending.
Huh?
13B petition is pending. In between, the counseling has been end and the court has fixed the date for final hearing for recording of the.
And when 13B petition is pending, how have they entered into second marriage? The second marriage is not valid.
She has already filed Annexure 4. She has given an affidavit.
Don't make the court a party to a illegal act. Why do you say that they are remarried? Divorce has not been granted. You remarried. Both of them. Have you written all these things here? Then I will not enter that. No, I will not be a party to it.
Divorce हो तो अपने तुम नहीं करोगे divorce करने मुझे कौन कर सकता है
ना लिखी चंदी के पढ़ो ना during pregnancy of the civil proceeding they have remarried.
Have you said anywhere that you have remarried?
Of them remarried.
I have been married to Abhishek Rudra.
In affidavit kindly of Annexure 4, page 43, lordship.
Paragraph 5.
Paragraph 5 only mentioned about remarried, but the pendency of the divorce pending without divorcing my first wife, that is mentioned.
Where have they said remarried?
Annexure 4, page 43, lordship. Your lordship's brief, lordship. Paragraph 5, lordship. That I have remarried to Abhijit Rudra Prasad Parida, son of Atal Bihari Parida.
Take this thing off the record. I will not do it. These are illegal marriage. How can I? 482 court, you want to, then you say that High Court has put a seal up for this thing. I can't do that.
Then petitioner to.
You can't do that, sir. I can't do that. Please appreciate what have you done. Your 13B application is pending.
Yes, ma'am.
Mutual divorce petition.
Yes, ma'am.
And before it is allowed, you enter into remarriage. And that you are making a part of record.
She herself on her own will say has governed the issue as a desert.
You can't make those things part of record in this court. Because tomorrow they'll say that the High Court has approved it. These are illegal marriages. I can't do that. So please change your pleadings.
There is no chance of reunion.
That is allowed. I can't make you understand. I can't make you understand. Please make you understand. It's a very dangerous thing. It can't be done. Did you follow? Your brother will make you understand and withdraw it, file a fresh petition. Don't mention remarriage. You are remarried, it's all right. You married, whatever you do it. Don't make it a part of court record.
My affidavit doesn't show that.
I know, I have seen that. That's a very tactfully drafted, but here he is making part of the record.
My lord, I may request your lordship, let petitioner be allowed to amend the petition, amend this petition.
No, but you take it off the record. Take it off the record. No repair work.
Case was
No
previously
repair work.
taken up by your lordship.
Your lordship has dismissed this case because I am outside girl, my lordship.
President, one last 2 to 3 weeks before your lordship, very fateful day, the wife is very rowing this allegation against her husband. Now,
Previous husband.
You do better, you withdraw it and file a fresh one, making all these amendments. I'll allow on the same day. That's not a problem. Allow it. Right. Let a counsel for the petition. I'll just withdraw, allow him to withdraw to file a fresh one. Let a counsel for the petition.
My lord, my request is an old lady. He is unable to come next time.
I can't help you. I am not exercising advisory jurisdiction. Still, I am telling you. You will be in trouble. I have to dismiss it. Let a counsel for the petition seeks to withdraw the petition to file a better one with relevant documents and relevant particulars.
Yes.
Liberty is granted to the petitioner to do so. You do it immediately and mention it. I'll take it up on the next day. Yes. Tomorrow you file it, mention it. Day after tomorrow I'll take it. To that extent, I'll help you. Okay. Yes. Okay. Do it. Let him do. You please tell him that. Because tomorrow it will be a very difficult thing for both of us. Yes. Next. Belgium.
Item 104.
104.
My lord.
NPW issued 7/5/24 and released on bail on 21/7/2016.
16. Fine. Yes. Okay. 500. Yes.
105.
5, my lord. NBW 17/7/2017. Bail 17/3/2011.
1000 each.
Oh, please, lordship.
6, NBW issue my lord 6/10/2019 man. Bail allowed 9/4/2018.
500. 1000. Yes. Yes.
107.
107, my lord. NBW was issued on 24/11/2023, my lord. And the petitioner was on bail since 23/12/2022, my lord. So 2002, my lord.
500. Yes.
Okay.
108.
NBW issued on 6/11/23, my lord. I was granted anticipated bail on 18/11/2019, my lord.
Okay. 500. Yes.
109.
NPW issued on 22 August 2022 and bail was 29 April 2014.
Okay. 500.
But the thing is, 2008 matter. This is talking list since several days. So the criminal appeal vigilance. But instead of mentioning equal lordship, matter has been taken up 113. Yesterday also mentioned lordship, you trial lock and everything.
I'll take it up at this.
Extension of time.
Tomorrow? Extension of time?
Only extension.
Extension of time for interim bails.
Belgium order is
116. For the reason stated in the application, it is extended till 20th. Extended.